Please, Lord.
Yes.
I beg to mention one unlisted matter, my Lordship,
For what?
for admission. The matter was from 2021 pertaining to non-payment of area salary and grade pay, revised grade pay.
Okay.
Lordship may be fixed on 13th.
May it please your lordship.
Hmm.
I beg to mention one motion item, my lord. It was earlier listed, but Honorable Court direct me to file an affidavit. I have filed on 26th of September, my lord, but the matter has not been listed.
16.
Oblige, your
Similar prayer, my lord. Any day. Lordship, I beg to mention for admission, Lordship. Matter of Lordship, 2 weeks earlier, 2 weeks granted, Lordship. Matter of Lordship, non-payment of monthly wages, Lordship. And 2 weeks of over now, Lordship. Kindly, this matter may be listed the day after tomorrow. No, next week.
Yes, your lordship.
18.
I beg to mention for contempt petition by lordship in the order states. Matter was last posted 21st 8 2023.
After vacation.
Yes.
May please lordship. Lordship, I beg to mention item number 21 of the daily list. Matter may be adjourned for the day
Why?
and any date may be given after vacation.
You've given your mention slip.
No lordship.
Then have you taken the consent from the other side?
No lordship.
Then let it be there. You take consent and come.
Okay, lordship. Oblige.
May it please your lordship.
Hmm.
Amended petition was filed on 4th October, which may be listed on Friday for the urgency.
Amended petition.
Amendment, consolidated amended petition on 4th October was filed.
Then come on 17th. 17th. 17th.
Can it be 16
Okay.
Friday?
Not Friday.
Much
Monday.
better.
Yes.
May I please, Lordship? I beg to mention for listing for motion, Lordship, on Friday, Lordship.
Why Friday? Monday.
Monday, Lordship. Oblige.
May I please your lordship. Lordship, I beg to mention item number 22. Lordship.
Hmm.
Lordship, my senior is not here due to some health emergencies. Lordship, can it be taken next week?
Who's your senior?
B Chakravarti, CGC lordship.
Have you taken the consent from the other side?
Yes, lordship.
Okay, on request made on behalf of
B Chakravarti.
E. Chakravarti, CDC. This is the matter of the 2 weeks.
Highly obliged.
Item 1 of daily list, admission.
My pleasure, Lordship.
Yes.
Lord, the petitioner before your Lordship is a retired employee of United Bank of India.
Hmm.
Now, Lord, United Bank of India has been merged with the Punjab National Bank.
Hmm.
And accordingly, Punjab National Bank has been implemented as respondent number 7. You are respondent number 7.
Yes.
Now, my Lord, issue involved before this honorable court is fixation of salary. Now, improper fixation of salary has a continuous effect, which has a bearing on the monthly pension.
Punjab National Bank is represented.
Yes. Yeah, as
Yes.
per respondent number 7. Respondent number 7, yeah? Respondent number 7 probably. Now, Lord, the petitioner was appointed in the year 1972 as a clerk of the bank. Now, the scale of pay of the clerk is for a period of 20 years span. Now, on completion of 19 increment, one employee would reach to the stage of stagnation. Now, if he is a graduate, then he will get two increment more, two increment. So he would attain the stage of graduate stagnation on completion of 17 years of service. So petitioner was appointed in the year 1972 and 17 years completes in the year 1989. This is the only thing, Lord. Thereafter, Lord, on reaching to the stage of stagnation, you would get one increment on completion of 3 years of service. Lord, I have stated here. Paragraph 3. At paragraph 3, I have stated. The petitioner, while serving as an assistant, attained the scale of stagnation in the year 1989. It is pertinent to mention that when an employee reaches to the stage of stagnation, he would not get yearly increment, but he would get stagnation increment on completion of every 3 years of service. In the instant case, the petitioner's first stagnation increment occurred in the year 1992, because 3 years, 1992. Second stagnation increment occurred in 1995, third occurred in 1991, and fourth occurred in 2001. But here is the case, Lord. Now, what happened? During his tenure of service, he was implicated with the disciplinary proceeding for unauthorized absence. And an inquiry was held. And in this inquiry, your proposed punishment, your lordship would find at page, proposed punishment, at page 10.
Yes.
Now, here, the proposed punishment in the matter of disciplinary proceeding against you. A departmental inquiry into the charge is against you in the bank's letter number such and such, dated such and such was held, observing the principles of natural justice. It appears from the proceeding of the inquiry that the reasonable opportunity was given to you for conducting your defense at the said inquiry, and that you have fully participated in the inquiry. Inquiry report of the inquiry officer was also sent to you by letter dated 25/5/2001, and your representation 15/6/2001 by your letter dated such and such. Now, here it is very, very important. I have carefully gone through the considered records of the inquiry, evidence, documents, the findings of the inquiry officer, and your submission against the said findings. And after careful consideration of the aforesaid documents, I concur with the finding of the inquiry officer, and I am satisfied that the evidence recorded at the inquiry, all the charges leveled against you in the said letter of charges have been proved and established beyond doubt. Now, here what they have proposed. After considering the facts and circumstances of the case, the gravity of misconduct of and your past record, it has been, here it is very much clear, it has been tentatively decided by me. Your lordship may make an underline, tentatively decided by me to impose upon you the undernoted punishment. That is a tentative decision. Generally, all the decisions are tentative decision. Your basic pay be brought down to lower stage in the scale of pay by 2 stage. One thing. Second, Lord, be censured. Now, here again it is stated, but before I take final decision, that is very, very important. with regard to the punishment as stated above, you are hereby given an opportunity of being heard personally in terms of clause 19.12 of the bipartite settlement dated 19-10-66 and on the nature of proposed punishment. On 22nd June 2001 at such and 3 p.m. at my chamber at Zonal Office, Guwahati, Uluwari, Guwahati, such and such. Accordingly, you are advised to remain present at the said hearing on the date and the time and the place indicated therein above. You may, however, submit your written representation if you prefer to do so with regard to the said punishment instead of appearing in person. But in that event, when the written submission should reach is understood on or before 5 p.m. on the 22nd June 2021 positively. So this is the order. Now, my lord, I have submitted a representation. Now they have taken the final decision. That decision will find, I have not annexed that representation, but that is not very pertinent so far this case is concerned. We are concerned with their decisions, effective date of their decision. Now, my lord, here, your lordship will file page 12, final decision. Further to my letter dated such and such, 18/6/2001, and after going through your written representation dated 12/7/2001, with regard to the proposed punishment, I have carefully considered your submission in the backdrop of the inquiry proceedings, connected papers, then documents, and inquiry report, along with your past record. On due consideration, your submission have not been found tenable and justified. In view of the fact and circumstances of the case, the gravity of proved misconduct, I find that the proposed punishment of lowering down of 2 basic pay by 2 states has been just proper and it cannot be reduced. Accordingly, I confirm the proposed punishment and finally the following punishment be inflicted upon you, lowering down basic pay by 2 states. Initially, they are proposed with censure and lowering down of basic by basic pay. Initially, what was their proposed? Now they are finally lowering down of basic pay by 2 states. This order was passed on 13/7/2001. Your lordship may kindly record this date. 13/7/2001. Now what they have done inadvertently, this effective date of the punishment was considered by them as the proposed punishment, date of proposed punishment. Your lordship, come to page 10 again.
Yes.
Here, the proposed date of punishment was 18/6/2001. Annexus A. Now, Annexure B, the date of punishment, 13/7/2001. Now, your lordship, come to page 13. Now, here, at my instance, they have produced the pay fixation that your lordship will find at page 13. Reference fixation of fixation of pay on account of punishment of C. Devashish Das, the petitioner, such and such number, SPF number such and such, which refers to your letter dated 1/10/2011, the pay structure of the above incumbent before and after promotion as follows. In the meantime, he was promoted to the post of manager. Now, my lord, here the pay structure when he was a clerk. Now, your lordship will find as on 1/6/2001, his basic pay is 8,980. Now, what they have done, Lord, as on 8/6/2001, that is the date of punishment. Actually, this is not the date of punishment. This is the date of proposed punishment. Annexure A. That will Now, so what is the effect? Now, on that day itself, my lord, they have inflicted this punishment. My basic pay was 8,980, and on that day, they inflicted 7,920 on that day itself. It should have been done on a subsequent date. Now, my lord, my date of increment is 1st July of every month. 1st July of every month. Now, final punishment was passed on 13 July 2001. So, prior to that, on 1st July 2001, I was entitled to have an annual increment, stagnation increment on completion of 3 years from 98 to 2001. And that was not given. And that has affected me. And accordingly, my lord, if your lordship come to my prayer of my writ application, at page 8, the petitioner's scale of pay in the grade of assistant shall not be revised by conferring one more stagnation increment, which was due on 1/7/2001. And they have inflicted punishment on 13/6 or 18/6/2001. It should have been 18/7/2001. Had it been so, then this increment would have been awarded to me. And after awarding of this increment, this punishment would have been inflicted. And as this infliction of the punishment was not made at the due time, and as a result, my lord, I was deprived of one stagnation increment. And this has a consequential effect in the fixations of my salary to the promotional grade and etc. etc.
Yes.
Second is the petitioner scale of pay in the, as it was not done, what was its consequence? The petitioner scale of pay in the grade of officers grade 1 shall not be properly fixed with reference to the due actual pay in the grade of assistant. Had it been fixed on 1/7/2001, then my scale of pay would have been defined in my promotional post. Now, petitioner's salary at the time of retirement, as a result, petitioner's salary at the time of his retirement shall not be rectified with the consequential benefit as accrued for gratuity and the due pensionary benefits. This is my basic case before you, your lordship. In the meantime, Lord, your lordship may note that in the meantime, I was promoted to the post of officer grade, and I attained my age of
Grade 1.
No,
You promoted to officer grade 1.
grade 1. I was promoted to the office grade 1, but the grade 1 post, my salary was fixed in terms of the scale as I drew in the clerical grade, as it was not with the reference to the one stagnation increment, some difference was there. There is a accumulative communication. This is a great gearing, but I am now drawing my pension, giving my pension, but actual amount of pension is not being paid to me because of that. This is my actual case before your lordship. Though I case filed in the year 2015, but because of these or that reason, it could not be heard in due time because of Corona, and subsequently bank was merged with the Punjab National Bank. I have to amend all these things. This is my basic prayer before your lordships. And I think the town of my learned senior consider what you say. And then it depends on it.
Lord, everything is depends on what is the legal position. Now, my lord, your lordship may kindly see paragraph 3. that the petitioner, while serving as assistant, attained the scale of stagnation in the year 1989. Now, my lord, his claim is that he is entitled to get 6 stagnation increment. There is no pleading, my lord, under which bipartite agreement you are entitled to. Now, the bipartite, so far fifth bipartite agreement, my lord, we have given him total 5 stagnation increment, but he is entitled to only 3. I'll read it, my lord. The stagnation increment, which stood as on 1989. Memorandum of settlement dated 10th April 1989 between the management class banks as represented by the Indian Banks Association and their workmen. So these agreements comes in view of Section 18 of the Industrial Dispute Act, and it is binding on all. So, my lord, since his stagnation is claiming in the year falls in the year 1989, this provision, I mean this memorandum, which took place on 10th April 1989, this will govern the field. Now, your lordship, I'll read it. Stagnation increments, both the clerical and subordinate staff shall be eligible for 3 stagnation increments at the rates and frequencies and subject to the terms and conditions as enumerated below. Now, if they are entitled to only 3, whatever they have got in access to additional increments, stagnation increments, they have got it. So therefore, how they are saying that their pay scale has been reduced? Therefore, these things, my lord, they did not highlight in their pleading. They will have to say that under which bipartite agreement you are entitled to 6 stagnation increment. I think he is required to highlight that first. Otherwise, under the 5th bipartite agreement, they are entitled to only 3. And we can make a recovery in regard to the excess payments made to them. So this is in short my reply.
If bipartite agreement came into effect from?
This is from 10th April 1989. And under that, my lord, only
Three stagnation.
yes, my lord, 3 stagnation. And admittedly, my lord,
Is that holding the field today? No.
yes, because it is from 90. Now, subsequently, my lord, it has been changed because now possibly in the 2000 they have increased it up to 5. Earlier it was 3. Now that also, my lord, I can take your lordship. This was modified, my lord, in the 7th bipartite settlement dated 27/3/2000. That is modified in partial modification of clause 5A of bipartite settlement dated 14th February 1995. Both clerical and subordinate staff shall be eligible for 5 stagnation increments. Now it has been increased to 5. Earlier, my lord, they are entitled up to 3 only. So this is the legal position as on today. So therefore, my lord,
So
whatever.
there's no such thing as a 6th.
No. 6th hasn't come yet. Subject to what my learned friend says.
Yes.
No, my case is not dependent on this, whether 4th, 5th or 6th. This submission, I don't think that has any bearing.
No. On what basis are you claiming the 6?
No, I am not claiming 6 of them. Where, if your lordship come to play my prayer, I don't know where from my learned friend.
Earlier you were submitting that on the 1st of July.
Yes,
You're supposed to get another stagnation increment.
yes.
Correct?
Yes,
So
that is the case.
earlier you got five stagnation increments.
No.
correct?
If your lordship come to page 13, yes, now your lordship come to page 13. It is a 3rd stagnation. 18/6/2001, when this that is the date of punishment. You are at the bottom, 3rd stagnation. Apparently, if I admit his submission, my lord, then also, my lord, I have a case. Because on that date itself, let me consider what my learned friend has said as a gospel truth. That I do not I cannot get more than 30 stagnation. Let me assume these things. I am not going to any controversy whether this bipartite or that party modification of that part. All these things I am not bringing all this. Let me assume his argument to be gospel truth. Now, what he stated is I am entitled to such stage of increment, and that was awarded on me on 18/6/2001.
No, I don't get your point.
Huh?
Come again.
Yeah. Your Lordship, come to page 13.
Yes, I'm on 13.
First column, second column, third column, vertical column. As on 18/6/2001. Got it? That is the date of punishment.
Yes.
Actually, date of punishment is not 18/6, but 13/7/2001. Now, on that day, that is at the third stage stagnation. At the bottom, your Lordship. Got it? So, if I consider my learned friend's submission as correct, then also, my lord, on the third stage of stagnation, it was not properly imposed. Because my date of increment is 1/7/2001. And date of punishment is 13/7/2001. So my third stage of increment would be arrive on 1/7/2001. Lordship got it?
Yes.
Lordship. So after giving this third stage of increment, stagnation increment, the punishment should have been inflicted. So had it been done so, then my third stage of increment had been would have been awarded to me. This is my case, beloved.
So you got your third stage of increment when?
On 18/6/2000, date of punishment.
Lordship may see paragraph 6. That will make the picture clear. वो पढ़िए ना, 6 पढ़िए. In terms of the order of punishment, the petitioner's basic scale of pay were lowered down by 2 stages in the year 2001. It is apposite to mention that the petitioner's fourth stagnation increment is to be given on 1/7/2001. But this fourth stagnation increment was not given in the year 2001. It was extended to the petitioner in the year 2003, that is on 1/7/2003. The petitioner's fifth stagnation increment accrued in the year 2004, that is on 1/7/2004, but the same was extended in the year 2006, that is on 1/7/2006. The petitioner's sixth stagnation increment accrued in the year 2007, but the petitioner had not availed this stagnation increment. This is his case, my lord. He is saying he's entitled to get 6 stagnation increment. That was not given to him.
Yes, no. By way of reference, I am stated so. Well, what is my prayer is that your Lordship will find at page 10.
That I've seen.
Oh. Now, I have stated in my petition that my third stagnation increment is due in the year 2001.
According to you,
But
this page 10 letter where the proposed punishment was notified to you, that was on 18/6/2001.
yes,
It was only tentative.
tentative.
And the actual date of infliction of punishment was on 13/7/2001. So normally you get your increment by the 1st of July of every year. Or after every 3 years, stagnation. So on 1/7/2001, you should have got your third increment. Then only after that the punishment should have been inflicted. That way the calculation went wrong.
Yes,
Is that correct?
yes, yes. That is my case.
That is your whole- You are not asking for the
Six. If he's not asking for six, then the matter is ended, my lord.
No, only thing is this, he's supposed to
Hello,
get the
Your
third stagnation increment on the 1st of July
Yes.
2001.
To that extent, I will consider.
Yes, that's it. If he
That
considers, then my
part
case is
he has not received,
Yes,
because according to them,
yes.
punishment was inflicted on 18/6/20.
That was proposed.
Yeah, that was only a proposal,
Yes,
but the actual date was on 13th of
13/7.
July. So when 13/7 was on that date, when the punishment was inflicted, he should have got the third stagnation
Yes,
increment on
yes.
1/7/2000.
Right.
Basically, that is your.
That is the case.
Now, let him make clear, my lord, whether he received fourth and fifth
No, no, no.
stagnation increment. or
No, no.
not.
Actually,
If they have received it, my lord, then how they are saying that their shortfall in his, my lord, the basic pay and the salary? Because if he has received fourth and fifth,
no, I think this is my due.
no, you just tell whether you received or not. There's no question, my
According
lord.
to you, para 6.
His other argument, my lord, yes, is very correct. It ought to have been on 1/7.
That
Yes.
part is clear.
That part is
But the fifth in the sixth increment, or the fourth in
fifth.
the fifth, you are not claiming for 6.
No. Now, I'm not also not claiming 4 or 3. I have simply stated it was due.
My lord, my anxiety is, let him say whether he received fourth and fifth stagnation increment. If he hasn't received, then it's okay. It is in
Have you
terms of-
received 4th and 5th?
That I can't say. Now, even if I assume that I have received, then how it has any bearing with regard to my sector fixation of skill?
Then there will be excess amount in.
Because had it been fixed on the basis of the third stagnation, then I would have get more than this thing. And fourth and fifth was a lesser amount.
No, but according to this page 13,
Yes.
Yes.
you got the 4th and the 5th also, isn't it? Last para,
Fourth and fifth.
last column.
Yes.
It is there.
It is there.
There.
So you must have got it.
Yes, yes.
Now, in that case, how is losing, my lord? They have received excess.
How?
How means under the bipartite I have shown. If you have any sort of confusion, you clear it. It was there,
Why
my lord.
don't you get a proper instruction whether you got the 4th and the 5th? Otherwise, the issue is very simple.
Simple.
Yes, sir, yes.
If you have not received 4th and 5th and you are claiming for the 3rd, then senior counsel is conceding.
No, up to that, it is okay.
He is conceding. But he wants to clarify whether you got the 4th and the 5th.
Yes.
If you have not received, then matter is simple.
Yes,
It
matter
can
is
be
very
closed very easy.
You get the instruction.
In
Get
terms of
some
bipartite settlement,
The
Fifth
fifth
bipartite.
bipartite settlement.
Let him prepare it.
no, fifth. It is rough and fine.
Why not you get some instruction and come back? If you have not received 4th and 5th, case is very simple.
No, even if I
You are
receive 4th
You
or
are
5th,
supposed to get your 3rd by 1st of July, 2001. After that, the calculation will go on.
Hmm.
But if you have received 4th and 5th, then according to senior counsel, you have got some excess payment.
no, all that, even if I got some excess payment, that can be recovered.
Why not you ascertain and come back?
If his case is that they paid me and it was an erroneous payment, so it should be recovered. I don't think, Lord.
No, that is a different thing. That's a different thing.
Yes, yes.
But then we want to be very sure whether you got a 4th and the 5th technician.
Probably I received because they have stated so. Anyway, I will.
Not probably, but let us be very
Yes,
sure.
we'll have to.
After that, we can dispose of the matter.
And at this distance of time, possibly, my lord, the bank will not go to recover all that.
Obviously, he has retired also.
Yeah, he's retired.
Hmm.
So let him make sure whether he's received or not.
Probably I have received because it is stated here on your as on 1/7/2000 fourth stagnation, as on a such and such fifth stagnation. Is stated. Probably I have received these things.
Let us be sure.
Fine.
But it does, senior counsel assisted by Mr. MS.
He does.
He does. Yeah. Also heard Mr. S. Datta, senior counsel assisted by Mr. K. Upaman. K. Upaman.
Hey, Upamanam.
K. Upamanian and the counsel for the respondent. All respondents.
Respondent, yes.
For all the respondents. Then the senior counsel shall assert whether the petitioner has received the fourth and fifth
Fourth and fifth stagnation increment.
Increment. Stop. When do you want this? 2 weeks? Will it suffice after puja?
If it is 2 weeks, then it will go after puja.
Yes.
Date may kindly fix. Otherwise, it will be difficult to get the matter.
When do you want? First week?
Yes. Subject to convenience of my. Bada okay.
You want it on a hearing day? 9th. No.
God bless.
So may it please your lordship. Lordship, the issue really arises because of bifurcation of what is erstwhile ASEB, which was a state board under the state, into a government company, APDCL. At the time of reorganization, the employees were assured and promised that the terms and conditions of service will not be worse off because of this reorganization. And in fact, that is also the mandate of the law. By the impugned decisions now, they have relished from that promise, and that is the subject matter of this writ petition, your lordship. Lordship, may I show you the agreement? The first.
Other parties are all represented?
Yes.
State of Assam is a party.
So state of Assam is a party. Finance. You are appealing?
State of Assam through
You are appealing? You have our department.
Our department, perhaps my learned friend can appear.
You are appealing?
No, my friend will appear. I'm
1 and 3.
I'm appearing for 4, 5, 6, 8, 9, and 10.
Okay, finance. Finance has any say in this matter? Not before something you say.
Right, my friend can begin.
Yes, lordship, 4, 5, 6, 8, 9, 10 is the relevant respondents, and they file their affidavits.
When respond.
Main respondents, yes. And they file their affidavit, we file reply. So we can go on, I think. Lordship. So, lordship, the first document in time is page 27.
Yes.
This is the tripartite agreement between Government of Assam, Assam State Electricity Board, that is ASEB, and the Employees Association, assignees of recognized association, etc. Lordship, this is dated 9th of December 2004 between the Government of State of Assam, represented by so-and-so, and ASEB and Employees Association. Lordship, what's relevant for us is paragraph 1. May I read your lordship? Whereas the state government has declared its policy of restructuring the electricity sector and is notifying the transfer scheme under section 133 in accordance with the Electricity Act 2003 for the purpose of restoring the operational and financial viability to meet the future demands of sufficient supply of energy of energy, provide quality service to consumers, and bring out the board from the present revenue deficits. This is the objective of the reorganization. Lordship, preamble 2 is important. Whereas the employees' representatives have expressed apprehensions that there would be adverse effect on their service conditions and retrenchment in the services, resulting in loss of employment. Para 3, whereas the state government has stated that such apprehensions of the employees are unfounded. Lordship, 4 and 5 is not really relevant. 5, Lordship, now therefore, it is agreed by and between the parties as follows. Lordship, C, which concerns us, and it's important. The terms and service conditions upon transfer to the successor entities shall not be in any way less favorable than the present terms and conditions under the ASEB. In fact, endeavor would be to rationalize the terms and conditions to provide for reasonable career growth and other welfare measures more beneficial to the employees, recognizing that employees are an essential part of growth of the power sector and in operation in an economic and efficient manner. Any change of existing service conditions such as seniority, promotion, transfer, leave, pay, allowance, etc. shall be regulated by the existing service rules, regulations in vogue, unless it is modified by mutual consultation and mutual agreements. This is the agreement and the assurance, Your Lordship. Then, Your Lordship, finally, page 33 is when the reorganization happens. And March 2003. Page 33, Your Lordship. In exercise of powers under 133-31 of Electricity Act, the governor is pleased to reorganize ASEB with the dissolution of ASEB, etc., to successor entities, which is APDCL, and it's 3 different companies, Your Lordship. One is distribution, the other is grid corporation, and power generation. And Lordship, the last line is here. This will come into effect from 31st March 2013. And Lordship, there's a scheme. The scheme really doesn't say anything much about the employees, except that, until proper orders are coming, they'll be constituting a common order. So what is relevant is only the agreement. Now, Lordship, the mandate of the law, which is the most important thing, page 40. Which is Electricity Act 2003, Your Lordship. We've just extracted the relevant provisions. Lordship, 131 is the basis of reorganization. What I showed you, the agreement, this is how ASAB got reorganized. Page 42 is 133.
Yes.
133.1. The state government may, by transfer scheme, provide for transfer of officers and employees to the transferee on vesting of properties, rights, and liabilities in such transferee as provided in 131. Clause 2. Upon such transfer, under the transfer scheme, the personnel shall hold office and service under the transferee on such terms and conditions as may be determined in accordance with the transfer scheme. Now, what is most relevant is a proviso. Provided, and Lordship, this is a central act, provided that such terms and conditions on the transfer, shall not, it's not may not, shall not in any way be less favorable than those which would have been applicable to them if there had been no such transfer under the transfer scheme. So it's very carefully worded. It says, terms and conditions on transfer shall not be less favorable than those which would have been applicable if there had been no such transfer, which basically means whatever would be applicable to you as ASEB will continue to remain. And there'll be no detriment caused because of this reorganization. So if a particular pay grade is increased as ASEB or the state, it'll be applicable to you. So terms and condition will remain as though there has been no transfer. That is the mandate of the proviso. The terms of conditions will remain as though there has been no reorganization. Whatever terms and conditions applicable to the board will remain applicable to you even upon transfer. Lordship, that is the law. Now, Lordship, the next page. Page 43. Lordship, till 2016, the pay remained the same. The board always got X+1. So there was 1 plus increment, their cadre 3, and all the petitioners were appointed before the reorganization. So what happened, Your Lordship, is we were always historically since 1958, when the board was constituted, it was X+1. So the board, the electricity board always got, the grade 3 electricity board always got little bit more, 1 plus increment than the rest of the grade 3 in the state. And that remained till 2016, till this notification came in. This is for the state. And Lordship, the government of Assam is pleased to order the following amendment in the schedule. And Lordship, basically the effect of this is that at page 45, the grade pay has been increased to 6,200. Junior assistant, 6,200. So until now, Your Lordship, we got, as ASAB, we used to get 5,600 and they would get 5,400. And that remained. Now we get 58. Their 56 has gone to 6,200 by virtue of this as a state government notification. And Lordship, may kindly see the next page. Page 47, 49, Your Lordship. Which is 29 September 2018. Lordship, this, the page 43, which I showed you, the pay rise is August 2017. And this says it's in continuation of that. In continuation of 25th August 2017, Lordship has it?
Page
49.
Yes.
The date of this notification is 29 September 2018. And it says in continuation of this department's earlier notification dated 25th August 2017, which I just read out, where there was an increase of pay to 6,200. So the government of Assam is pleased to allow the benefit of pay in the pay band and the grade pay as allowed in the ministerial staff, which is basically grade 3 employees of the district establishment with its counterpart in head of the department to all similar categories. So Lordship, basically grade 3 has district cadre, headquarters cadre and secretariat cadre. By this notification in the state government, what they did was they said the headquarter pay grade and pay band of the headquarter department and the district department will be the same. So they upgraded the district department to the headquarter department and said district cadre will get the same thing as the headquarter cadre. By virtue of which they got 6,200. So this is applicable to the whole of state government departments in grade 3 level. And our grievance is that had we remained in ASCB, this would have been applicable to us. And this is denied by virtue of this reorganization in breach of 133 of the Electricity Act. Lordship, this is the second round of litigation. There was, to discuss all of this, there was a rationalization committee. Lordship may see page 55.
Yes.
It's dated 5th of January 2019. It says in partial modification of so-and-so order, the committee is hereby reconstituted to suggest rationalization of services, service conditions and service rules of all cadre under APDCL, APGL, AEGCL. The composition of the committee will be as follows. The Lordship has that. There are 9 members. One is a member convener. And it says, Shri Vishwajit Gogoi, so-and-so will assist the committee. And the last line is important. The committee will submit the report by 8th February 2019. Lordship, they did not do that, so we came to court. And the order of the court is at page 61. At 64 is, at 64. Starts at 61.
Yes.
Paragraph 2, Lordship. This also brings out what our grievance is. The petitioners, Lordship has page 64, paragraph 2.
Yes.
The petitioners are all employees of Respondent APDCL. Prior to creation of APDCL, the petitioners were employees of ASEB. And during their service tenure as employees of ASEB, their service conditions were same as the government of Assam in similar rank and position. After the creation of APDCL, their service condition remained the same with that of the employees of the government of Assam. By notification 29/9/18 of Government of Assam in Finance Department, it was provided that the government of Assam was pleased to allow the benefit of pay band and pay grade to the ministerial staff of the district establishment. Lordship, this is the notification I showed you where the headquarters and were merged and they were upgraded in the State Department. Being aggrieved, the petitioner raised a grievance of the benefit of pay in the pay band and grade pay as allowed to the ministerial staff of district establishment has not been extended to the employees of APDCL like that of the petitioners. This is the core of our grievance. Consequent thereon, the service conditions of the petitioners have been adversely affected. Paragraph 3, Your Lordship. On grievance being raised, the chairman by office memorandum so-and-so dated 5/1/19. Lordship, I showed you that office memorandum had constituted a committee to suggest rationalization of services conditions. Paragraph 4 is important. The composition of the committee has also been provided in that said order of 5/1/19. The office order of 5/1/19 specifically provided that the committee would submit its report by 8/2/19. Lordship, I showed you that. The petitioner enclosed the meetings of so-and-so committee dated. A reading of the minutes show that the committee has not arrived at a decision. So we had come to the court saying that they were supposed to give a report by 8. They haven't. Kindly please direct them to give a report. And that is exactly what happens, Lordship, paragraph 6 and 7. In view of the mandate that the committee is required to submit a report by 8/2/19, we are of the view that more than enough delay has already been caused and no reason for such delay is discernible in the minutes of 9/6/20. Para 7 is important, Your Lordship. In view of the same, this petition stands disposed of by directing the committee constituted by the office order of 5/1/19. It's very specific. It says directing the committee constituted by the office order of 5/1/19 to conclude the proceedings and submit the report as required within 3 months from the date of receipt of the certified order. Lordship, so there's a mandate to the committee constituted under page 55. I showed you, Your Lordship, to come back and give a report. Now, Lordship, see what they do. Lordship, they have their affidavit in opposition. And this is a preliminary objection, Your Lordship. Not objection, Your Lordship, preliminary submission. Lordship, you have, Your Lordship, affidavit in opposition. Page number,
Yes.
you have that, Lordship. Page 7.
Internal.
Internal, yes, Your Lordship. Running page, I say.
Yes. And next year.
Lordship, I don't have running page. So is it okay if I go by internal? Page 7, Your Lordship, annexure A. Lordship has annexure A, page 7.
Yes.
Lordship, this is the impugned decision by the committee. And Lordship, look at the committee. Lordship may keep page 55, which is the mandate direction that this committee may go ahead and do it, page 55.
Yes.
The mandate was clear. The committee constituted by 5/1/19 to give a report. There are 10. Composition is 10. There are 12 composition. And I checked, Your Lordship, if the position is the same and the personnel change. No. MD remains, M1, 2, 3 remains. 4 is different. If even CGM, if FANA is not here, CGM DSA is not here, CGM OM is not here, HRA 9 is common. So it's a completely different committee. And they don't even come to this court to say, we've reconstituted. So therefore, please give us liberty to change this and review your order. The mandate very much was this committee. And they go ahead with a committee which is not as per. So that is a preliminary submission that they should have at least come to the court. Because it's at the end of it is a mandamus, Your Lordship. Lordship may see the order, it's a mandamus. Page 65. By directing the committee constituted by office order dated 5/1/2019. So this is a breach of the Mandamus, is our first submission. That at the end of it, the committee that actually took the impugned decision was without jurisdiction. If they wanted to reconstitute, it was incumbent upon them to come back to this court and Lordship make a prayer and say that committee is not available. So therefore, can we please modify the committee and go ahead with anything? They did not do that. They just went ahead and do it. That's a preliminary submission, Your Lordship, which is that the committee is without jurisdiction and therefore must be set aside on that ground itself. And Lordship, the famous case of Madan Mohan Pathak, that if there's an mandamus issued, you either do it that way until it's reviewed or repealed. And I submit, Your Lordship, that this is a mandamus. Direct the committee constituted by office, or it was not directed any committee. Direct the committee constituted by office order dated so-and-so to conclude the proceedings. So on grounds of without jurisdiction, this decision must be set aside. Lordship, should I let them answer that or go straight to merit again?
Go straight.
To merit? Now, Lordship, on merits, it's a very short point. It's page 42 and 133. Section 133 proviso. Read with the agreement.
Page?
Page 42, Your Lordship, where we have put section 133 of the Electricity Act. The Electricity Act, Your Lordship, is a central, it's the act that consolidates the old Supply Act, 48 Act, and comes to one act of 2003, which provides for reorganization. So this is the section right after reorganization. Lordship, 133 we put, this is thing. And Lordship, it's an interpretation of the proviso. Our submission basically is the assurance and the mandate, both, because the agreement also I read out, Your Lordship, clause 5, and the mandate of the law. The agreement actually resonates the mandate of the law. The mandate of the law is that if you want to reorganize APD, the erstwhile electricity board, you may do so. But when you do so, you must ensure that the employees' terms and conditions remain as though they were never moved out of APCL. So whatever is applicable to APDCL, or would have, it says, which would have been applicable to them. It's very, very succinctly put, which would have been applicable to them if there had been no such transfer. And our submission, my submission is that 2017 and 2018 notifications where the pay hike is increased in the State Department, Lordship, the district and the headquarters merge now. If I had remained in ASEB, the state, if I had remained ASEB, which is a department of the state, that notification would have been squarely applicable to me. And I would have got a benefit of the merger and the pay hike, which we have been deprived. That is this thing. Lordship, may I take you through this is a short point on law. And Lordship, the impugned, may I take you to the impugned minutes and their reasoning. Page 7. Apart from it having no jurisdiction, it is wrong in law. Page 8. Observations and recommendations. May I read, Your Lordship?
Yes.
The committee examined the matter in the wake of writ petition 4321 and Honorable High Court order 2010-20, which I showed you, the mandate they breached, to conclude proceedings and submit the report within 3 months from the date of order. As regards the demand of the petitioners under provision of 133(2) of the Electricity Act 2003 that the terms and conditions of service would be less favorable under the transfer scheme, the committee is of the view that section 133(2) is not applicable. So, Lordship, they are saying that it is not applicable. A mandate of law is not applicable to the present case. They don't say why. The 3 cadres existed even prior to the unbundling of ASEB into 3 separate companies for generation. It's important now. The next 2 lines are very important. The terms and conditions of service of the petitioners and their pay has never been less favorable than those which they have been receiving and enjoying prior to the unbundling. This is their understanding. That at the time of transfer, if the terms and conditions were same, in 2004, when I transferred, if the terms and conditions were same at that point of time, then there is no problem. We are all good. And 133 is not applicable. I can understand. Either you say 133 is applicable and it's not breached because the terms and conditions are frozen on the date of transfer. So if on the date of transfer, the terms and conditions were not less favorable, later that the state has given a better, more beneficial treatment to their own departments does not guarantee that you'll get it. That is what they're saying in the last two lines. The last two lines are saying terms and conditions of service of the petitioner has never been less favorable than those which they have been receiving prior to. They're saying it's not an ongoing obligation. 133 is not an ongoing obligation. 133 basically says that on 2044 or whatever, whenever the reorganization happened, if you got X, when you transfer and became APDSA, you'll also get X. If later in point of time, the state government hikes the pay grade, there's nothing we can do about it. That's a state government. Because our obligation and assurance is only at that point of time. Because what you've been receiving prior, you got at the time of transfer. Now, if this is the meaning that they give to 133, then 133 is ocious. And Lordship, there's one more point of 133. Lordship, may kindly go back to page 42. Which is important for reading of the proviso. 134, Your Lordship. Lordship has 134?
Yes.
Notwithstanding anything contained in the Industrials Act or any other law for the time being in force, the transfer of employment of officers, employees referred to subsection 1 of 133 shall not entitle such officers and employees to any compensation or damages under this act or any other law. So the act precludes us employees upon reorganization from any redressal forum. And it only makes sense because there is a mandate of the law which says you will not be treated less favorably. So if the mandate of the law is you will not be treated less favorably than those which would have been applicable to you if you had not been, then they say you can't come to anybody and ask for different things because we've assured you. Now, if the interpretation which the committee is giving is that this is frozen in time. I gave you, when you transferred, I gave you. Now, later it happens, then first of all, the meaning of terms and condition also is ocious because terms and conditions of service includes more than just the pay. So that means if at one point of time when I transfer is frozen, then later on there is nothing else. It's basically the whole assurance is completely meaningless. That is this thing, and my submission is 134. It further reiterates my submission that this is a protection given that we are transferring you, but your terms and condition will always remain as though there has been no transfer and you remained in ASAB board under the state. Lordship, that is my submission. There's one Supreme Court case, Your Lordship, which I rely on, and I think it squarely covers Lordship, here the issue was whether 133, section 133, which I'm relying on the proviso, it protected the employees from treatment that would be prejudicial. That was squarely the point, okay? And the finding is that erstwhile employees are protected and their terms and conditions cannot be altered to their detriment. Lordship, may I read the facts? Because a little bit of facts will be important. Sorry, I'm so sorry. 2022 SEC online, SC 198. 2022 SEC online, SC 198. Yeah? It's Muhammad AA versus Kerala, state of Kerala. Paragraph 2, Lordship, the facts. Writ petition so-and-so filed in Kerala for a declaration that regulation 116 of Central regulation 2010 is ultra virus, the regulation making powers of the authority under Electricity Act, and also saw a declaration that the state of Kerala has no power to allow deviation under sub-regulation rule of regulation 16 in respect of qualification prescribed in regulation 6 and 7 of the safety rule. A further relief that order dated 13/2/19 issued by the state of Kerala is arbitrary. Actually, what happened here is 2010 regulations are regulations under the Act for safety. And what they did was they added certain more degrees for purpose of safety. And I'll show you that, Lordship, but just in a gist. So there were additional qualifications that one had to get for the sake of safety of managing the electrical stuff. The Kerala, there was a power under the same regulations for the central authority or the state government to deviate. The state of Kerala, Lordship, this is the state of Kerala. The state of Kerala understood 133 as I have sought to submit and said that, sorry, the people who, there was again a reorganization. So the employees who got erstwhile employees, you can impose a new condition now to their detriment and cause them their prejudice. So 133 protected those. So it's an ongoing thing. The scheme was in 2008. These regulations came in 2010. And they said, sorry, this new qualification, the state themselves came out with a regulation with an order exempting them from this, saying in view of 133, they are exempted because a new qualification will be to their detriment, and we have promised the same terms and conditions will apply. Lordship will become clear. Lordship, may I? Paragraph 3. Lordship, issue 2 is what is relevant for us. Can the Lordship has issue 2?
Yes.
Can the provision of a scheme framed under 133 read with 133(2) of the Electricity Act 2003 offer any protection to officers, employees who do not possess the qualification required in terms of the safety regulations? Paragraph 4, Your Lordship. Issue 3 is not relevant. Paragraph 4, the division bench of the High Court held that 160. Lordship, here the challenge were people who had the qualifications. The state was very clear that 133 protected them, and the state came up with an order exempting them. But other newly engaged employees came and said, sorry, you want us to give this examination and hold these, and this is in public interest and for public safety. So not imposing this particular qualification to erstwhile is actually arbitrary and actually against public interest. That was the challenge. That's how they came. The division bench of the High Court held Regulation 116 of the safety regulation is neither ultra-virus Electricity Act nor manifestly arbitrary, and that it is well in line with the object's purpose of the enactment. It held that the framing of the regulation 116 is not ultra-virus. 116 is what gave the deviation and is not beyond the scope of rulemaking power. Now, Lordship, what is important is here. This is what the division bench held. Referring to section 133(2), which is what I'm relying on, the High Court was of the opinion that the exemption from the applicability of Regulation 6 and 7 of the safety regulations by order dated 13/2/19. Lordship, this is the state government order. The state government understood 133 proviso to grant protection to the erstwhile, came up with an order saying this new regulations will not be applicable to them. Therefore, said, referring to section 133, the High Court was of the opinion that the exemption from the applicability of Regulation 6 and 7 of the safety regulation by order dated 13/2/19 can be granted only in favor of persons who were employed by KSEBL, which is the new APDCL, on the date of formulation of the transfer scheme, and such of the employees who have joined service after 13/10/13 were not entitled to such exemption. So the order, Lordship, was blanket. It says anybody from these new qualifications are not required for anybody who was appointed before 13/2/19, the order of the order. The High Court narrowed it and said, sorry, 133 gives you protection only for those people who were working before, erstwhile, before the reorganization. So what it did was, it says the exemption from applicability of Regulation 6 and 7 by order dated so-and-so can be granted only in favor of persons who were employed by KSEBL on the date of formulation of the transfer scheme, and such of those employees who have joined after 13/10/13, that's the date of the scheme, are not entitled to such exemption. This was the division bench. They narrowed the protection, the deviation. They narrowed the deviation and protected and said only those people who were already there, the deviation is applicable to. So this is the division bench, Your Lordship. Then Your Lordship may come to paragraph 8.
Yes.
Paragraph 8 summarizes that there is a central electricity authority and that it is to specify safety requirements for constructions. The central authority then has the power to make regulations. Paragraph 9. Lordship has paragraph 9.
Yes.
The central electricity authority measure relating to safety and electric supply regulation 2010 were brought into force in 2010. The relevant regulation 6 and 7 relate to safety measures. And Lordship may see 6 is basically they're saying whole diploma. There's 2 years of, so they added more degrees as a part of requirement. Safety measures for operation, people who are appointed to operate require these additional degrees. Paragraph 10. So 6 and 7 introduce new qualifications in the interest of safety. 10 of the same regulation. Further, regulation 116 of the safety regulation empowers the central government or the state government to allow deviation in respects of matters so and so. Para 11. Part 13 of the Electricity Act pertains to reorganization of KSEB. According to the objects and statements of regular, one of the features is to make so and so. Lordship, this is just to say it's exactly the same situation. There was a reorganization. Lordship may read 1, 2, 3, 4, 5, fifth line from the bottom, the same paragraph. Paragraph 11, the state governments. Lordship has the state governments were given option of continuing.
Yes.
Continuing with the state electricity boards under the new scheme of things would be a distribution licensee and a state transmission utility, which would be owning generation assets. That's what happens. Next line is important. It provided that service conditions of employee would, as a result of restructuring, not be inferior. It's exactly the same situation. Lordship may now come to paragraph 14. Just to say, Lordship, the scheme was 2008, was notified in 2013. Lordship, now paragraph 15, just to bring out the similarity. Lordship has paragraph 15.
Yes.
Subsequently, so there was exactly a scheme, and then there's a tripartite agreement. And Lordship may see the wording of the tripartite agreement. It's exactly similar. A tripartite agreement was entered into between the state of Kerala, KSEBL, and Union, exactly like how in the present case, representing workmen, etc. The state government and KSEBL assured the existing employees that the terms and conditions of service, such as promotion, transfer, wages, compensation, leave, allowances, etc., upon transfer of KSEBL, shall continue to be regulated by existing regulations, services, rules in vogue. This is pari-matery 2-page, Lordship, which I read out in our agreement. Clause 5. Lordship remembers that. Lordship, page 28, 29. I'm only highlighting because they rely on this. And 133 to say it's an ongoing obligation and it's an assurance that you will always treat them as though they were a part of the erstwhile unit. Lordship may see paragraph 29, page 29, sorry, Your Lordship, page 29, last 4 lines of the paragraph. Any change of existing service conditions such as seniority, promotion, transfer, leave, pay allowance is not just it's terms and conditions of service, not just one aspect. So it can't be frozen in time. It can't be that I was a junior assistant and I'm treated as junior assistant and I will always for time, by treating me as junior assistant, the assurance is complete. It says Any change in existing service conditions such as seniority, promotion, transfer, leave, pay allowance shall be regulated by the existing service rules conditions invoked unless. Exactly the same, Your Lordship. Now let's come back to paragraph 15. Paragraph 15, Lordship, is, I just wanted to show that the agreement is exactly worded. Now, Lordship, paragraph 17. Lordship, I'm making you go through so much of this fact just to show that facts are exactly the same. And because it's a central act, Your Lordship, I mean, it's the reorganization happened pan-India. Pursuant to powers conferred by state government under 133 of the Electricity Act, a transfer scheme was prepared in 2008, vesting the functions, interests, rights, obligations, liability of KSEB in the state government. Thereafter, another scheme was prepared in 2013, transferring the functions, properties, all rights and air into a fully owned company of Government of Kerala. As contemplated in the transfer scheme, a tripartite agreement I just read out of 2014 was entered into between so and so, so and so, so and so. Now, Lordship is important. This is the impugned order. By an order dated 13/2/19, the Government of Kerala ordered deviation from implementation of the qualification prescribed under Rule 6 and 7 of the safety regulations for the existing employees of KCAB in exercise of powers under Regulation 16. The deviation was applicable to employees working with KSEBL on the date of the order dated 13/2/19 and for all future appointments and promotions. The qualification prescribed in 2010 regulations was strictly followed. So there was a carve out, but the government notification carved out everybody prior to. The division bench narrowed it and said not everybody prior to, only the erstwhile because of 133. The grievance of the appellant. It's interesting here because the state did not question 133. The state implemented 133 and brought about a deviation. The grievance of the appellant is that the state possess the necessary qualification required, they possess the grievance of the appellants is that they possess the necessary qualification required under Regulation 6 and 7 of the regulation, and the decision of the government to deviate from the requirement of 6 and 7 to make ineligible employees fit for promotion to higher posts would be detrimental to the interests of the appellants. That was their contention. The main contention raised by the appellant is that the deviation permitted by the order would amount to compromising safety norms by the authority, which would adversely affect larger public interest. This was their contention, which was rejected because of the protection of 133, and that's the next paragraph, Your Lordship. Paragraph 18. Reorganization of the Electricity Board has been done in terms of Electricity Act by preparation of a transfer scheme as contemplated in Section 131 of the Act. According to Section 133(2) of the Electricity Act, the transferred personnel are to be governed by terms and conditions as may be determined according to the transfer scheme. The proviso to 133(2) protects the interest of the transferee insofar as the conditions of services are not to be less favorable than those which would have been applicable to them had the transfer not taken place. Lordship, then it goes on, clause 6. Lordship, the last 1, 2, 3, 4, 5th line. It is clear. Lordship, and they again re-quote the agreement, Lordship, actually. May I read the whole paragraph? Clause 6 of the transfer scheme provides transfer through promotion. The transfer scheme in clause 8 contemplates execution of a tripartite agreement between state government, etc. Lordship, you have the parties entered. The line parties entered.
Yeah.
The parties entered into such a tripartite agreement in which it was agreed that the promotion of the existing employee shall be continued to be governed by existing rules, regulations in vogue. It is clear from the above discussion that the service conditions of the erstwhile employees of KSEB are protected by the proviso to Section 133 of the Electricity Act. After the transfer scheme was formulated, the erstwhile employees were entitled to claim that terms and conditions of service cannot be altered to their detriment in view of the agreement. This is finally what I rely on. Lordship, and then to complete, Lordship, paragraph 24.
Yes.
Lordship, paragraph 25. And this makes it clear the protection is available to whom. Because the Kerala order actually protected everybody, as on date of that order. The division bench says, sorry, 133 protects erstwhile. And the Supreme Court reiterates that. The next question that requires to be examined is regarding the exercise of powers of Kerala in issuing the impugned order dated 13/2/19. Drawing from the interpretation of the relevant provision as discussed above, promotion and other service conditions of the officers and employees transferred to KSEBL under the transfer scheme are protected under section 131 and 133(2) of the Electricity Act in conjunction with transfer scheme and tripartite agreement. The explanation to section 133 makes it clear that officers and employees referred to that section are only those officers and employees of the board on the date of the transfer scheme, that is 31/10/13. By no stretch of imagination can this protection be extended to those employees who were engaged after. So 133 protects those who were there on the transfer date. Lordship, and they say it's dismissed. So Lordship, this is the finding that I rely on is this. It is clear from the above discussion that service conditions of erstwhile employees of KSEB are protected by the proviso to 133 of the Electricity Act. After the transfer scheme was formulated, erstwhile employees are entitled to claim that conditions after scheme was formulated, the erstwhile employees are entitled to claim that conditions of their service cannot be altered to their detriment in view of tripartite agreement. So your Lordship, in this case, they were applying a qualification that was detrimental. In our case, they're refusing to extend a benefit which would have been applicable to us had we remained in ASCB. And our prayer is that those notifications should be applicable to us had we remained in ASCB. And this reorganization had not happened, we would have been part of the state, in which case those would have been available to us. We would have got the same pay hike and same grade pay. And Lordship, in the minutes, they say that we already get a lot more. That's not really what is in dispute. Historically, since 58, when the board was constituted, we were X+1, the pay band. So we got more than the grade 3. That was our service condition. So that we got that all throughout doesn't mean that now they don't have to do anything about it. We are on grade pay. Grade pay was increased from 56 to 62 for them. For us, we got 58 because we were X+1 and it has remained. That is the core of our submission. And we rely on 133 and the Supreme Court judgment. This is over and above that the committee is without jurisdiction and should be set aside, and we can make these submissions again before the right committee. Oblige, Lordship.
What happens if the members are not available now?
Lordship?
What happens if those members are not available now?
Lordship, there is a designation. If you,
So in terms of the designation,
whoever is the personnel, Lordship, there is IAS MD, there's MD, there's MD. I can understand them saying that, the designation was conformed to, the personnel changed. It's not even that. I checked. It's not even that. First of all, it was 9 hours become 12. And Lordship, my prayer is what Madan Mohan Pathak says. Lordship, I may place that. If you want to change a mandamus, you come back to the court that directed the mandamus and say, it is not possible for us. That's a mandamus. There's a mandamus to you that that committee constituted under 5/1/19 must give a report. If it's not possible, it could be that's not possible. Some personnel is not there or some particular composition has to change. The respect for mandamus demands that you come back to the court, move the court and apprise the court and say, this committee can't be according to this. May we have permission to, that is a preliminary submission. Because after all, it's a mandamus.
Doctor, if I may address the preliminary submission first. At page 55 is the list of people who will be members of the committee.
Page,
55 of the writ petition.
yes.
So MDs of the three successor companies of the erstwhile ACB lordship, and then the CGM LAR, the CGM HRA, the CGM Central Assam region, Upper Assam region, headquarters, finance and accounts. Except the OSG, who was an officer on special duty and he was the member convener, all the other 9 officers were present on the meeting held on 11th of January 2021. So they were present there in that meeting. Some additional members were there, but these people were definitely there, Your Lordship. Your Lordship takes up our affidavit in opposition, page 7 of our affidavit in opposition.
Yeah.
Annexure A. So I just cross-checked. The MDs of the 3 successor companies are at 1, 2, and 3. The CGM Finance and Accounts is at serial number 4. The CGM Upper Assam region, that is UAR, is at serial number 5. The CGM Central region, Central Assam region is at serial number 10. The CGM Lower Assam region is at serial number 11. And the CGM CR is at serial number 8. So all of them, Your Lordship, who were mandated to be present as per the office order dated 5/1/2019.
Yes.
All of them except the member convener who was an officer on special duty to be chairman, except him, all of them were present. But 3 other, my learned friend has correctly pointed out, 3 additional people were there, Your Lordship, whose names were originally not there in the order dated 5/1/2019. So since the committee, which was supposed to be, the officers who were supposed to be present by the order dated 5/1/2019 were present on 11th of January 2021 also, Your Lordship. So there is prima facie no infirmity. The mandamus has been complied with, Your Lordship. That is my first submission. Because now I am not sure if the officer on special duty is still there or not, because that's a ex-cadre post. Probably then it existed, then I do not know the presence.
Yes.
Yes. If I may address Your Lordship on the merits, their primary contention is that under section 133, there is a mandate of law that the service conditions of employees of the erstwhile boards shall not be less favorable than the terms and conditions which were applicable to them when they were employees of the board. Now, there is no quarrel at all with that proposition. I accept it wholeheartedly. Now, the question is, Your Lordship, that were they entitled as employees of the service board to get equal pay with employees of the state government? That was not their service condition. They might have been getting equal pay. In fact, they might have been getting more pay, Your Lordship. But that was not a condition of service. If they can show from the record that, yes, one of our service conditions was that you will get X plus 1 equal to the state government, or you will get equal to the state government, then yes, if that is not being done now, then that definitely means something which is not in their favor, which is disfavorable to them after the formation of the companies. But if that is not a service condition, they might have been getting it coincidentally. But if that is not a condition of their service, then a company refusing to do it after considering his financial position, that cannot be said to be something disfavorable to them, Your Lord. They have to first establish that they were entitled to that.
which they have not done. They have said that we were getting it definitely, but that was a condition of service applicable as per some notification or service rule. They have not said that. They have not brought anything on record. I also tried to find out. I could not find out to the best of my ability. Now, Your Lordship, what has this committee said in its report? Because initially their prayers were twofold. Perhaps they have given up on one prayer now. First, they wanted the merger of three cadres of the chairman, head of department, and district cadre. They wanted to be merged in one cadre. And if it is, that was one prayer. And the second was regarding that they should be given the benefit of the revision of pay. Now, perhaps since my learned friend has not raised the question of merger of cadre, perhaps that may not be necessary to go into right now. Perhaps they are not taking that up, Your Lordship. But the committee, Your Lordship, that was one of the demands of the erstwhile employees that was addressed. So I'll just take Your Lordship to the observations and findings of the committee at page number 7. I'll read from background. Due to repeated requests from representatives of several unions who are also members of the district and head of department cadre, this Assam State Electricity Supply Mazdoor Union, Assam State Electricity Workers Union, AACV Grade 4 Employees Union, Assam State Power Workers Union. The matter regarding merger of the three-tier ministerial cadre system into one tier was discussed in the various meetings of the committee constituted for rationalization of service conditions and service rules of all cadres of APDCL, AGCL, and APGCL. The committee initially recommended the merger of the three cadres in its meeting dated 13/11/2019 without soliciting responses from all three cadres. Thereafter, responses were received regarding the proposed merger. The meeting was held on 9th of June 2020 with the members of the three cadres who are also the representatives of the unions. In the meeting, the representatives of the head of district and head of department and district cadre supported the merger of the three-tier ministerial cadre system to one tier, while the representatives of the headquarter cadre strongly objected to the proposed merger. In this regard, the AACB Headquarter Administrative Employees Association also submitted a representation dated 18/6/2020 against the proposed merger. The matter was discussed in the subsequent meetings of the Committee for Rationalization of the Service Conditions and Service Rules dated 26/6/2020 and 11th September 2020, and the committee did not recommend the proposed merger as there was no consensus amongst the representatives of the three cadres regarding the merger. Most importantly, the committee in the meeting dated 26/6/2020 discussed about the financial implication associated with the proposed merger, and it was seen that amongst the three cadres, the HQ, the headquarter, head of district and head of department and district cadre, which has a total strength of around 129 numbers, the district cadre alone has an employee strength of around 1106, whereas the employee strength of headquarter and head of district is merely 15 and 8 respectively. Also, out of these three cadres, only district cadre has service rules at present, and their promotional avenue and criteria is fixed up to the level of circle superintendent, pay scale W12. The other two cadres do not have service rules, and their promotional avenue is as per precedence. It was found out that as the employee strength of district cadre is more in comparison to the other cadres, there will be an additional financial burden if the proposed merger happens, and the promotional avenues are allowed up to the level of W14 for all cadres, that is HQ, HOD, and district cadre. The committee also discussed that no further requirement should be made in the HQ and HOD cadre, and deliberated the matter should be placed before the Board of Directors APDCL for its consideration. Consequently, after the retirement of the headquarter and head of district cadre employees, only the district cadre will remain. The committee in the meeting dated 11 September 2020 was of the view that as per the minutes of the meeting of the Committee for Rationalization of Service Conditions and Service Rules dated 26 July 2020, 26 June 2020, the proposed merger of three-tier ministerial cadre to one tier will not happen. And also there shall be no further recruitment in the head of district and headquarter cadre, which is subject to approval in the APDCL board meeting. Now, Your Lordship, regarding their first prayer, that for merger of the three cadres into one, that is perhaps taken care of because we have said that since only 15 employees and 8 employees in one cadre, there shall be no further recruitment. And as and when those employees retire, it will all become one cadre. Finally, it will all become one cadre. Now, regarding the second prayer, Your Lordship, regarding the grade 2, that is taken care of in the observations. Observations and recommendations. The committee examined the matter in the wake of WPC number 4321 of 2020 and the Honorable High Court's order direction dated 2010-2020 to the committee to conclude the proceeding and submit the report within 3 months from the date of order. As regards the demand of the petitioner under provisions of section 133(2) of the Electricity Act 2003, that the terms and conditions of service would not be less favorable under transfer scheme, the committee is of the view that section 133(2) is not at all applicable in the present case. The three cadres even existed prior to unbundling of ACB into separate companies for generation, transmission, and distribution. The terms and conditions of the service of the petitioners and their pay has never been less favorable than those that they have been receiving enjoying prior to the unbundling. This is the crucial statement, Your Lordship. The terms and conditions of the service of the petitioners and their pay has never been less favorable than those which they have been receiving / enjoying prior to unbundling. And that is precisely why, Your Lordship, section 133, the proviso, would not be applicable in this case. Because if we had changed it to their detriment, or rather not changed it to their detriment, if they were entitled to get equal pay with the state government employees, or even X+1 pay, they might have been getting it. If they were not entitled, Your Lordship, then there is no reason for us to adopt it unless it is financially suitable for us now. Because now we are a company where commercial considerations, Your Lordship, we have to take care of them. My learned friend has already taken a Lordship to the rest. Just 2 lines on the next page, Your Lordship. On page 9. The third para.
Yes.
Regarding the merger, they have said further there will be approximate financial involvement of ₹3 crores per annum. If the merger happens and promotional avenues are enhanced in accordance with the HQ cadre, considering the stress financial condition of APDCL, with accumulated losses, the merger of the 3 cadres would not be feasible. Thereafter, Your Lordship, at page number 11,
Here it says the committee was reconstituted
yes, Your Lordship.
with partial modification.
Which Lordship?
The second last para.
It may be mentioned that the committee provide order dated 19/12/2018 to suggest rationalization of service conditions and service rules for all cadres under APDCL, AGCL, and APGCL. The said committee was reconstituted with partial modification by order dated 5/1/2019. This is the order, Your Lordship, under reference in the writ petition, page 55 of the writ petition. On the basis of its various recommendations and minutes so as to serve service conditions of other cadres also, many actions have been taken by the Board of Directors. This committee holds periodical meetings to discuss various matters relating to service rules, and minutes of the committee are issued accordingly. This is the notification under reference in the writ petition, Your Lordship, at page 55. Considering all the above aspects of the matter and upon a threadbare discussion, the committee is of the considered opinion that the state government notification dated 29/9/2018 on pay band and grade pay need not be independently and or separately implemented in the APDCL, and the merger of 3 cadres into 1 cadre in ministerial service cannot be recommended. So both the contentions, Your Lordship, were rejected. Thereafter, Your Lordship, the same on 22/1/2021 was communicated to the petitioners at page number 10. And at page number 11, Your Lordship, a formal notification was issued. As per resolution number, I'm reading from page number 11, Your Lordship. As per resolution number 26 of the minutes of the APDCL board meeting held on 30th June 2021, the Board of Directors of APDCL took note of the minutes of the meeting of the Committee for Rationalization of Service Conditions and Service Rules held on 11th of January 2021, particularly on merger / amalgamation of 3-tier services and applicability of government notification dated 29 September 2018 on pay band and grade pay in the wake of the order of the Honorable High Court in petition number 4321 of 2020 and accepted its recommendation. So, due to our financial consideration or condition, Your Lordship, we cannot now give them the grade pay, Your Lordship, which they are asking for at par with the state government employees. And section 133, Your Lordship, would not be applicable since there was no service condition under the AACB which entitled them to get equal pay with the state government.
Let us read that 133 again.
Yes, Your Lordship. Next page. Petition was yes, sir. I think it is annexed to the petition also. 42. The state government may by a transfer scheme provide for the transfer of the officers and employees to the transferee, which is APDCL now, for these employees on the vesting of properties, rights and liabilities in such transferee as provided under section 131. Upon such transfer, under the transfer scheme, the personnel shall hold office or service under the transferee on such terms and conditions as may be determined in accordance with the transfer scheme. Provided that, this is the important part, such terms and conditions in the transfer shall not in any way be less favorable than those which would have been applicable to them if there had been no such transfer under the transfer scheme.
It says those which would have been applicable to them
Yes,
if there had been no transfer.
yes. Now, unless the AACB would have adopted, it may or may not have adopted the transfer, the revision of pay, your lordship. That is in the realm of speculation. Now, presently, your lordship, when our financial condition does not allow us to do it, and there was no mandate that AACB was bound to adopt whatever revision of pay rules are formulated by the government. They might have adopted them by practice, but unless there is a right vested on the employee that yes, my service conditions mandate that you have to adopt them, then they cannot say that those conditions are not are disfavorable to them, your lordship. And presently, your lordship, that they have not been able to establish that. That when I was in the AACB, that my service conditions were such that I was entitled to get the same pay as or X+1 pay as the government employees. And so as and when or if our service conditions improve, we will definitely reconsider as and when, your lordship. Because now, right now, the committee has said that it is not feasible for us. And the law regarding that is also clear, your lordship, that the writ court perhaps may not like to impose an additional financial burden, lordship, when there is no right vested on the petitioners. Yes, they might have been getting the payment, your lordship. But that would not entitle them, that would not entail that the right has vested in their favor. Unless the service conditions mandate. Your lordship, there are two judgments that in policy, since this is in the realm of policy, the court may not like to interfere. I'll not trouble your lordship by reading to them, I'll just place them on.
I will not dispute that proposition.
That is all.
Which one?
Uh,
2003.
Yes, 2003 4 SCC, 289. Para 12, your lordship. And the other one is 2020. No, other one is a Madhya Pradesh High Court judgment, your lordship, which perhaps, your lordship, just because I tried finding out if some similar matters have been, some disputes have been raised by employees in other boards, your lordship. There was this one matter from the Madhya Pradesh High Court where the petitioner was the promotion of employees of erstwhile. It was a reference matter, and the court held that change in service conditions, your lordship, there is an explicit change between the two service conditions, I mean between the board and the successor company, then they would be entitled to the protection of 133 and not otherwise, your lordship.
I'll rely on that judgment.
Yes, if there is a change, then they would be entitled to change. But if there is no change, then there cannot be.
Para?
Lordship,
Citation to define.
yes. Citation is 2014-1 MPLJ, page 439.
Yes.
Paragraph number 11, your lordship, onwards. In context of what was just the law is discussed, your lordship. There is no quarrel with that proposition. 11, 12. That is my submission.
Yes. Your respondent?
I am for the respondent numbers.
4, 5, 6, 8, 9, 10.
4, 5, 6, 8, 9, and 10.
Meet Mr. Lordship. Lordship, I am paying on behalf of respondent number 1 and 3, Lordship. Basically, Lordship, I want to point out only one or two things, Lordship. One is, Lordship, there is a FR and SR, Lordship, which basically deals with the general condition of service of some government employees, Lordship. And the pay allowances and Lordship, retirement benefits, Lordship. Here, Lordship, under to satisfy to get the benefit of a state government employee, Lordship, here's that employee has to undergo that FR2, which says, Lordship, the fundamental rules apply to all government servants whose pay is debitable to civil estimates of Assam.
No, that is not the issue here. Anyway, proceed.
No rules modifying or replacing any of the fundamental rules that adversely affect any person who is in government service at the time when these rules come into force, except under the direction of an authority competent or empowered to make such a rule under paragraph subsection 3 of section 241 of Government Committee 1925. So, Lordship, my humble submission is the Lordship for employees under the company Lordship, APDCL company, Lordship, to get the benefits of employee as that of state government. So whether their Lordship, their pay is debitable from the fund of the government or not, Lordship, because this APDSL, they used to create their own fund, Lordship. Accordingly, Lordship, they does not get the benefit as what state government employees are getting, Lordship. Secondly, Lordship, there is a notification of 2017, Lordship, which is basically, Lordship, it's a scheme, Lordship, a modified career progression issued scheme, Lordship, to get the benefits. So what does it say, Lordship? At para number 10, Lordship, the first service standard in public sector undertaking under any other state public sector undertaking, autonomous bodies, is that
Where are you reading from?
Lordship, it's a notification of finance department.
You
Lordship.
should have a copy. You should have a copy ready for all the
Lordship,
parties,
basically,
including the court.
I'm sending it to the email of the court, Lordship.
How about the other parties, the petitioners and the other respondents?
Other respondents is finance, Lordship.
Then have you got copies? At least let the
No,
petitioners.
we have not
also
filed our affidavit, Lordship, till now. So we have not filed our affidavit. That is true. So I'm appealing for the first time today.
We have gone so far. Petitioners completed his argument. Respondent for today has completed. Now you are filing out talking about.
No. The thing is that I'm only appearing for respondent number 1 and 3. Here, basically, APDCL has rejected the
Correct.
benefit. So they have already appeared under the finance department. And these are, Lordship, these are point of law, Lordship. These are already there, Lordship. These are not on facts. So I can place it anytime, Lordship.
So that's why I'm saying, where's the notification you are reading from?
Lordship, which is a notification of finance department, Lordship, of dated 6 July 2017.
So you're reading from your mobile.
No, Lordship, I'm
Let
sending
us
a,
have-
I'm
let us
sending
have
a copy to him right now, Lordship.
Date to Kobana?
Yes. 6 July 2017.
6 July.
2017.
Notification of
Notification of Government Office of Finance Pay Research Unit Department.
No, you don't do you bring copies, circulate it to the your learned friends and a copy for me. After that, I'll discuss. I'll hear you.
Lordship may keep it part heard then.
I'll have to keep it part now.
Lordship, if any other respondent also wants, then next time it should not be.
Correct.
Mhm.
Where's the finance? Ms. G. Goswami.
Yes, Your Lordship.
Also heard Mr.
KP Pathak.
KP Pathak. Then it's Standing Council, JBTC. For the respondents, 4, 5, 6,
And
8,
9,
8,
4, 5, 6, 8, 9, and 10.
8, 9. Yes, Chalia, you have anything to say in this matter? So you have nothing to say.
Until unless they raise some queries which needs to be answered, we have nothing to answer.
Also heard Mr. A. Chalian and Standing Council Finance for respond number 2 and 7. And Mr.
CKS Bora Lordship.
CKS Gora, then
Bora. 1 and 3 Lordship.
government advocate
Lordship.
for respondents 1 and
1 and 3, no?
3. Okay, part. When can we have it? After puja only we can take it. List for the hearing on immediately after puja.
Yes, Your Lordship, otherwise everybody will forget, Your Lordship.
Yeah, maybe you'll have to resubmit again. 9th. 9th. Is it
Ninth, Lordship.
9th of November?
Obliged, Your Lordship, obliged.
plea,
Yeah, please, Your Lordship. My lords, as per the last order, 14/9/2023, we are directed to, my lord, complete the Finance Department Principal Secretary. So accordingly, we have filed a IA, that is today's listed, my lord, 2905, for implement of the Principal Secretary Finance Department as per number 5, my lord.
My lord. My lord, I am appealing for higher education, my lord. Unfortunately, the file got misplaced, my lord, today.
No, this is for implement.
Implement, my lord.
If you have any objection, that's a different issue.
Respond number 5 is the Finance Secretary.
Yes, no.
On what ground are you implementing finance secretary?
My lord.
On what ground are you making the implement? On what grounds?
My lord, because the last occasion whenever Lordship was taking the case, my lord, my lord, my lord, my lord Pathak, my lord, that was pointed out that to give the complete relief to the petitioner, Finance Department is essential. So that is why, my lord, court observed that he is to be impeded. Accordingly, my lord, we made him party.
Okay, hurt Mr.
P. Mahanta.
Yamanandal, and it counts for the petition, applicant. So, by this application, the applicant is praying for implementation of the Principal Secretary to the Government of Assam, comma, Finance Department, comma, 3rd floor, comma, Chief Ministerial Block, Janata Bhavan, Guwahati District, Guwahati 6. As party respond number
5, my lord.
5, in WBC number
WBC number
4376 of
76.
2021. On the ground that in order to get complete relief and justice, the aforesaid implementation, aforesaid party is required to be implemented as necessary party. Mr. As thus, then the Standing Council, Higher Education has no objections. But on perusal of the course shown in the present application, this court is also satisfied. And accordingly, the prayer for implementation is allowed. In the amended petition, in view of the order passed today, so let's so and so be implemented as party respond number 5. In the present petition, petition is directed to file an amended cost title within a period of 1 week.
My lord.
Cost title.
Cost title, my lord, 81.
Within a period of 1
Yes.
week. List the matter after 1 week.
And my copy may be served, my lord.
No, I'm going to issue notice only after you serve, only after you file it. There's a notification now.
Yes,
Once any amendment is made, you'll have to file an amended cost.
yes, yes, cross checking. Master.
May I please, your lordship? Well, this matter, my lord, is with regard to, my lord, the members of the consumer court. My lord, their
Reduce a complete,
please complete, my lord.
who appears on the other side.
My lord, finance, my lord, Malanas, friend PS, my lord, and so, my
Civil
lord,
supplies,
food and civil supply department, my lord.
finance, you have,
Yes, ma'am. For the respondent number 5, my lord. And others, my lord, so far as respondent number 1 to 4, my lord, my colleague will appear, my lord.
you are appearing on behalf of all the respondents.
Lordship, 1 and 4, 1 to 4.
Legal remembrance, sir.
Yes.
1, 2, 3, and 4.
You file your affidavit.
Yes, but the finance have already filed an affidavit.
How about the
Food and civil supply also fine.
File.
My lord, the petitioners, my lord, are very, my lord, appointed as members, my lord, in the my lord, state, district consumer dispute redressal forum, my lord. Now, my lord, they were appointed under the earlier rules, my lord. Now, as per that rules, my lord, they are receiving salaries of rupees, my lord. In fact, allowances of 650 rupees per day, as well as an allowance of rupees 150, my lord, per sitting, my lord, per day, my lord. So they get, so therefore, my lord, 750 rupees per day, that's what they're getting, my lord. Now, after the new rules, my lord, came in, my lord, in fact, the Supreme Court, my lord, said, my lord, that the state should frame their rules, or my lord, the central rule should be adopted. The state did not frame any rules, and my lord, state adopted the, my lord, central rules, my lord. And it's an immediate position, no one is disputing that, my lord. Now, my lord, the appointments that have been made, my lord, under that, my lord, rules, my lord, the new rules, my lord, which has been adopted by the state, my lord. Under that, my lord, the members are receiving, my lord, a salary of the deputy secretary, my lord, which comes to, my lord, around 69 to 70,000 per month, my lord. And whereas they are receiving something between 9,000 to 12,000 per month, my lord, on accumulation of, my lord, this daily, my lord, allowances and, my lord, fees, my lord. Now, therefore, my lord, we are seeking pay parity, my lord. Our basic case is, my lord, quantitatively, qualitatively, and then from all, my lord, angle, my lord, we are, my lord, discharging similar duties, responsibilities are similar, my lord. We form the quorum of the bench, my lord. We are part of the judgment, my lord. And, my lord, whatever duties the regular members, my lord, or the newly, my lord, appointed members on the new rules, my lord, are discharging, we are also discharging exactly the similar duties, my lord. Secondly, my lord, so where the qualification is concerned, that is also similar, my lord, bachelor's degree, my lord. Of course, my lord, in the new, under the new rules, my lord, the experience required is a little 15 years, my lord, in different fields, which was earlier 10 years. But we are all, my lord, having that qualification also, my lord, because some of them are more than members for more than 5 to 7 years, my lord. So they automatically, they have gained that 10 years plus experience also. 2 members who have, my lord, newly joined, my lord, they have also, my lord, we made a statement, my lord, they are, my lord, having that experience, my lord. Now, so far as, my lord, the department has not been able to point out any difference whatsoever in the duties we are discharging, or for that matter, the process of recruitment. The only thing, my lord, that is there was, my lord, that under earlier rules, my lord, when we were appointed, our appointments were basically on part-time basis. That is what the appointment letter says. And our case is, my lord, that though the nomenclature says it's a part-time, we sit, my lord, if the tribunals, my lord, in a particular district, the tribunal sits 3 days a week, we will sit for 3 days. If it sits for 7 days, my lord, we also sit for 7 days. So everything else is similar, my lord. And, my lord, we therefore our case is that of, my lord, that we are entitled to similar pay scale, my lord, as per the new rules which have been adopted. And the discrimination is, my lord, apparently, my lord, large, my lord. Whereas we are getting around 9 to 12,000, my lord, they are getting, my lord, around, my lord, for the same job, my lord, they are getting a pay of, my lord, around 60 to 70, around 70,000, my lord. So that is our basically our case. Now, lordship will find, my lord, that so far as our appointments were concerned, my lord, I have given a chart, my lord, when we were initially appointed. In fact, what has happened in the meanwhile, my lord, Few of the members, my lord, have already, my lord, completed their tenures. But, my lord, for the period which we are, my lord, if the lordship directs, my lord, the salaries to be paid, my lord, at par, my lord, we'll be, my lord, getting areas for that. Lordship will see page 8, my lord, is our, my lord, chart, my lord, from the date of appointment, my lord.
Page 8.
Page 8, my lord. Now, lordship will find the petition number 1, my lord, here, and, my lord, the petition number 5. These are the persons who were appointed in 2020 for the first time, before the new rules came in. But so far as the others are concerned, my lord, they were initially appointed in 2013 onwards, 2013. Then, my lord, they were, this terms were for 5 years. And, my lord, they were again appointed, my lord. So, my lord, and the dates of reappointment have also been, my lord, given, my lord, here. So, my lord, these people, my lord, have been discharging these responsibilities. Now, my lord, we, my lord, could not, my lord, did not keep our advertisements, but similar advertisement, my lord, we have kept, my lord. And, my lord, I have, my lord, the next one, the advertisement is page 22, my lord. Our appointment, my lord. It's a similar advertisement, not the one which under which we were appointed, my lord, but then this was the enormous, my lord, the rules that was being followed, my lord. Lordship will see, my lord, this is an advertisement dated 25th of January 2019. Now, lordship will find honorarium, my lord. Page 22, man. Member, my lord. First is the president, we are not concerned, my lord. Member, my lord. Consolidated honorarium of rupees 600 plus conveyance allowance of rupees 150 per day for sitting. Page 23, my lord, is spills over. A consolidated honorarium of rupees 600 plus conveyance allowance of 150 rupees per day for sitting. That is, my lord, what we are getting, my lord. Lordship will see the qualification, my lord. Eligibility criteria required. Possesses a bachelor degree from page 22. Possesses a bachelor degree from a recognized university. Secondly, be a person of eligibility, integrity, and standing, and have adequate knowledge and experience of at least 10 years in dealing with the problems relating to economics, law, commerce, accountancy, industry, public affairs, or administration. Now, my lord, this was the qualification, my lord, and earlier, my lord, the term used to be 5 years, my lord. Now, under the present rules, the term is for 4 years. Now, what has been shown, my lord, here is the nature of post, my lord. They were shown to be part-time, my lord. This is what, my lord. Lordship will find, my lord, page 22, the last column, my lord. Nature of post, part-time. Now, lordship will kindly have a look at the advertisement, my lord, which is under the new rules, my lord. Page 52.
Page
52, my lord. This is an advertisement published on 26th of August 2021, my lord.
Yes.
Yes, my lord. Lordship will find members, my lord. Second one, first is the president of the concern, my lord. Members, a person who is not less than 35 years of age, possesses bachelor degree from a recognized university. My lord, this is common to the advertisement, and is a person of ability, integrity, and standing. So this is also common, my lord. And a special knowledge and professional experience of not less than 15 years in consumer affairs, law, public affairs, administration, economics, commerce, industry, finance management, engineering, technology, public health, and medicine. So, my lord, here the experience is, my lord, in different fields is required. That is required is, my lord, 15 years instead of 10, which was earlier, my lord. And, my lord, lordship will find below, my lord, the selected candidates for the district commission shall hold office for a term of 4 years or up to 65 years of age, whichever is earlier, and eligible for reappointment. Now, my lord, this is under the new rules, my lord. Now, my lord, in 2019, my lord, the new Consumer Protection Act came, my lord. And thereafter, my lord, this matter was before the Honorable Supreme Court, my lord. Lordship will find that order at page, my lord, 40, my lord. So that order, my lord, starts at page 36, my lord. The relevant part will be at page 40, my lord. Well, we direct all the states and union territories should notify the rules within 2 weeks from today. in order to take care of the position, we're still the states dilly-dally on the issue of notifying the rules. We further direct that in the eventuality the rules under Section 40 of the State Act not being notified in 2 weeks, the model rules framed by the Government of India will automatically kick off and apply to all concerned states and union territories, that is the consumer protection and salary and allowances of and conditions of service of president and members of the State Commission and District Commission model rules 2020. Now, the state of Assam did not frame any rules. They adopted this rules, my lord, and that is an admitted position. In fact, my lord, that notification is also with, my lord, the state's annexure, my lord, affidavit is there, my lord. They have annexed that notification, my lord. At page 70, my lord, of the affidavit filed by the Food and Civil Supplies Department, my lord, respondent number 1, 2, and 3, my lord. Page 70, it's there, my lord. 70.
Yes.
My lord, whereas as per the appointment letter, so the members are entitled to honor and prescribed under the, my lord, this is pursuant to our representation, that is what they said, my lord. They are not entitled to salary and allowances prescribed in the consumer protection salary and allowances and conditions of service of president and members of State Commission, District Commission, Model Rules 2020, which has been adopted by the government of Assam. So it is an admitted position, my lord, that the Model Rules 2020 has been adopted by the government of Assam. My lord, I'll place that Model Rules, my lord. Yes, ma'am. This is the rules, madam. Yes, yes. The model rules and the model rules. This is the procedure. Well, this of course, madam, is not, madam, this is recruitment procedure, madam. This is recruitment, not the salary. Just, madam, I'll place, madam, the qualifications and all, madam. Here, which has been given an advertisement, madam. 4, my lord. Model rules 2020. Qualification. My lord, this is the qualification. My lord, just as in the advertisement, my lord, section 4, my lord. Sorry, rule 4, my lord. Qualification for appointment of president and member of district commission. A person shall not be qualified to be appointed as president. So this is not be a concern, my lord. Second 2, my lord. A person shall not be qualified for appointment as a member unless he is not of not less than 35 years of age, passes a bachelor degree, my lord, from the recognized university, and is a person of ability, integrity, and standing, having special knowledge and professional experience of not less than 15 years in consumer affairs, law, public affairs, administration, economics, commerce, industry, finance, management, engineering, technology, public health, or medicine. So that is what the advertisement also says, my lord. So this is the, my lord, so far the qualification is concerned, my lord. And, my lord, so far as the model rules are concerned, my lord, salary rules, my lord, that also I'll place, my lord. My lord, this is the rules, my lord. This is on 15th of July 2020, my lord. This is rule 3, my lord. So that says, my lord, that they'll be, my lord, entitled to salaries in the rank of the deputy secretaries, my lord. My lord, therefore, my lord, our case basically is, my lord, that, my lord, the pursuant to this, my lord, adoption of the new rules, my lord, the members who have been newly appointed, my lord, are receiving the salaries of, my lord, the deputy secretary, scale of deputy secretary. We are receiving the daily allowances, my lord, as per seatings, my lord. But everything else is, my lord, similar, my lord. There is no, my lord, difference qualitatively, quantitatively, or for that matter, in any other sphere in terms of responsibility, my lord. There is no difference at all. We enjoy the similar status of, my lord, that of, my lord, other members, my lord. We form the quorum of the bench, my lord. So therefore, my lord, under these circumstances, my lord, we work for similar hours that we have made very specific statements, my lord, in our writ petition, my lord. That, my lord, our duties are similar, my lord. For example, lordship will find, my lord, in page para 20 at page 16. My lord, before that in paragraph 19, we have said, my lord, that we have experience of 15 years, my lord, under the new rules also, my lord, where we, my lord, and my lord, paragraph 20, my lord, we say that the petition, page 16, my lord, that the petitioners are qualified to be reappointed under the new rules. It may also be pertinent to mention that the petitioners were, though appointed as part-time members, but the fact remains that the duties are similar to the members of the new under the new rules, which has no provision for any part-time members. In fact, the functioning responsibilities, duties of the petitioners and the newly appointed members receiving scale as per 2020 model rules are same in all respect, and they have to spend similar time in their jobs. And, my lord, under section, my lord, 31 of the, my lord, 2019 Act, my lord, Consumer Protection Act, our services are the old members, my lord, earlier appointed members, my lord, are protected, my lord, till they complete their new term, my lord. Consumer Protection Act 2019, section 31.
Two thousand?
19, my lord. New Act, my lord.
2019.
Well, I have.
But this is the addition is.
Well, earlier it was 1986, my lord. Now it has been replaced by 2013, 2019 rules, my lord. Section 31, my lord. Transitional provision. Chapter 4, my lord. Page, of course, the pages will differ, my lord. Chapter 4, Consumer Disputes Redressal Commission. And section 31 refers to the transitional provision. Has my lord got it, my lord?
Yes.
Any person appointed as president or, as the case may be, a member of a district commission, immediately before the commencement of this act, shall hold office as such president or, as the case may be, as a member till the completion of his term for which he has been appointed. So, my lord, though we were appointed earlier, my lord, our services are protected under this act, my lord. So we accordingly, my lord, continued, my lord, to service, but till service, my lord. As I've said, 2 persons, my lord, have in the meanwhile completed their tenure, my lord, in the month of June. And they have, my lord, they have attained, in fact, 65 years of age, my lord. Therefore, my lord, they're not eligible for reappointment as such, my lord. But, my lord, our services are protected. Now, my lord, therefore, my lord, in the earlier, my lord, Lordship, I can look at the affidavit of the my lord, the department, my lord, Food and Civil Supplies Department. Their only stand here, my lord, is that since we were appointed under the my lord, earlier rules, my lord, we will not be entitled to pay and scale as per my lord, the new rules. They have neither denied, my lord, they have not made any my lord statements denying my lord, my lord, our contentions, my lord, that we are discharging similar duties and responsibilities, my lord. And there is any difference in the my lord, duties, my lord, and services, my lord, of the parties, my lord, between the parties of the my lord, members, my lord, newly appointed members and the old members, my lord. So no statement has been made, my lord, to that effect, my lord. Now, Lordship will find my lord, this statement is very relevant, my lord. Paragraph 7, my lord, of their affidavit, page 67, my lord, of the affidavit filed by the respondent number 1, 2, and 3, my lord. While, my lord, they have not denied, my lord, that we are not entitled, my lord, to any, my lord, we are receiving, my lord, doing any, my lord, different service, my lord, our, my lord, that we are not qualified, etc., my lord. My lord, they are saying in paragraph 7 that, my lord, we can resign, my lord, and reapply for the post on the basis of advertisement. So, my lord, they are also admitting, my lord, that we can reapply for the post and, my lord, get new appointments, my lord. But they are saying that we should resign, my lord. Where is the question of resignation, my lord? We are saying we are discharging your duties, my lord. So accordingly, pay us whatever you are paying to the others, my lord, because we are discharging similar responsibilities. That is as simple as a case. On the other hand, their case, my lord, is that since we are appointed, my lord, under the earlier rules, my lord, therefore we are not entitled to, my lord, similar scale and pay, my lord. They are not trying to, my lord, distinguish on us on account of, my lord, having lesser qualification or, my lord, having to discharge lesser responsibilities or lesser duties, my lord. Nothing of that sort, my lord. And, my lord, with regard to the my lord, pay parity, my lord, the law is well settled, my lord. It is, my lord, the nature of duties, my lord, that is to be seen, my lord. If the duties are similar in nature, my lord, there is no question of denial of, my lord, the similar pay, my lord, to the persons, my lord, who are discharging similar duties, similar responsibilities.
You have any citations?
My lord, have citations, my lord. Well, one of the, my lord, judgments, my lord, is a Jagjit Singh, my lord, versus, my lord, State of Punjab versus Jagjit Singh, my lord. This is a very elaborate discussion on various, my lord, facets of, my lord, pay parity, my lord. In fact, there are a large number of decisions have been my lord, taken into, my lord, account before, my lord, discussing, my lord, giving the findings here, my lord. If almost, my lord, 24 to 25, my lord, judgments, my lord, have been quoted here, my lord. And, my lord, the distinctions which have been basically made, my lord, are, my lord, summarize for us. 58.
Paragraph 58, your worship. Page 2 to 3.
Yes. No, 58 is temporary employee. There is another. But before, my lord, going to the other decisions, my lord, I would just like to place one, my lord, decision, my lord, which has been referred here, my lord. My lord, that is been, my lord, Bhagavan Das, Bhagavan Das, the page number. Lordship will here find out that the various judgments that have been discussed, my lord, from paragraph 5 onwards, my lord. It was in terms of, my lord, in fact, my lord, various, for example, when in case of temporarily engaged persons, my lord, in fact, with regard to ad hoc employees, everything has been, my lord, discussed, my lord. And the emphasis, my lord, is on discharge of equal, my lord, responsibilities and duties, my lord. And once, my lord, that criteria is fulfilled, my lord. For example, my lord, of course, other things like my lord, who is paying the my lord, salary, my lord. That is also one of the consideration that has been given, my lord, one of the cases. Now, here is a case where the state is paying salaries for both, my lord. So there is no difference as to who is, my lord, paying the salaries, my lord. The appointing authority is the same, my lord. So all these processes have, my lord, similarities. There is no distinction at all, my lord, except for that word use of the word part-time, which was there earlier, there, my lord. And the salaries which are receiving, my lord, as, my lord, much lesser than what, my lord, there, the other members are receiving. That is the only difference that is there. My learned senior will submit.
What did the judgment 2017 one is I think you was having before also. Just have a look to page paragraph 42, my lord. Page 206. The only question is coming matter here that whether equal pay for equal work is available or not, my lord. Now, page 42.3, your loss can see. Page 206. Your loss got it, man.
Yes.
Now, the principle of equal pay for equal work applies to cases of the unequal scales of pay based on no classification or irrational classification. For equal pay, the employees concerned with whom equation is sought should be, your loss kind, should be performing work which, besides being functionally equal, should be of the same quality and sensitivity. Here we stand on the same footing, my lord. Sensitivity. Then your lossable kind, my lord, that page paragraph 47 and 58, my lord, I come to page 222.
Out of 47.
Yes. 57 and 58. Only my lord, those two brothers, that will not take much time on only principle of law.
Yes.
57 and 58. There is no room for any doubt that the principle of equal pay for equal work has emerged from an interpretation of different provisions of the Constitution. The principle has been expounded through a large number of judgments rendered by this court and constitutes law declared by this court. The same is binding on all the courts in India under Article 141 of the Constitution of India. The parameters of the principles have been summarized by us in paragraph 42 here and before. That 42 I have shown your lordship. Only one part I have shown to your lordship. So the parameters of the principle have been summarized by us in paragraph 42 here and before. The principle of equal pay for equal work has also been extended to temporary employees, described as work charge, daily wage, casual, ad hoc, contractual, and the like. The legal position relating to temporary employees has been summarized by us in paragraph 44 here and before. So that is also important, 44 also. The above legal position, which has been repeatedly declared, is being reiterated by us yet again. Then paragraph 58, only one paragraph, I will not take much. In our considered view, it is fallacious to determine artificial parameters to deny fruits of labor An employee engaged for the same work cannot be paid less than another of whom performs the same duties and responsibilities. Certainly not in the welfare state. Such an action, besides being demeaning, strikes at the very foundation of human dignity. Anyone, you must kindly note, anyone who is compelled to work at a lesser wage does not do so voluntarily. He does so to provide food and shelter to his family at the cost of his self-respect and dignity, at the cost of his self-worth, and at the cost of his integrity. For he knows that his dependents would suffer immensely if he does not accept the lesser wage. Any act of paying less wage as compared to others similarly situated constitutes an act of exploitative enslavement emerging out of domineering position. Undoubtedly, the action is oppressive, suppressive, and coercive as it compares involuntary subjugation. I think, madam, this is enough. I don't think some more decision your lordship will get here, madam. Only question, madam, the person having same qualification, same duties, same quality, same nature of the works, madam. Only whether they are entitled to get the 10 or 9 under the new rules, madam. In my humble submission, this judgment support us, and your lordship may consider they are entitled. My lord, they are getting only 19,000 right now, not 16. 9 to 12,000. Their counterpart is getting 69,000. Space able to the deputy secretary as per the 20 rules. That's what's much. So that your lordship is to see, my lord, whether I need to take up. That much, my lord.
Yes. Bhattacharya.
Yes, Lordship.
Other reason, if available, we will give to your worship.
Lordship, as it was posted in admission, Lordship, we are not that prepared for any final disposal, Lordship. But even though we'll rely on the affidavit that we have filed, because they are.
Yeah, your affidavit that we have read.
Yes, Lordship.
Basically, you're just a wishy-washy affidavit. Where you're not denying what you're saying also. You're not accepting what you're saying also.
Lordship, that's true. But the statement that we have stated here, Lordship, they also have not replied. They also have not disputed what we have replied, Lordship. This is also there. This is also there because we in Paris 67, Lordship, in para 7, we have stated that as there was parity in their all these things, what they are actually paying, because their representation has already been taken care of and disposed, Lordship. Thereafter, they were before your lordship, and we have stated that they have the opportunity, if they have qualification, if they have their required age, lordship, they can opt for when the next advertisement are issued, lordship, they can resign and they can opt for the next appointment, lordship. Because these two rules, lordship, because
are you saying they're doing different jobs?
Lordship, on that count, Lordship, we have not said, and without any instruction, Lordship, that I am not able to.
So that's why you come with all these instructions.
Yes, Lordship, because their nature of job and what they are doing with the post and pre-2020, Lordship, this clarification I need to require from the department, Lordship. Otherwise, I am not be able to submit anything on that count.
They have not denied it, madam. Duties, we are the same members, madam. If they say that we are not members, we are peon, we are clerks, then of course got some sense, madam. We are the members of the consumer forum, madam. So what further instructions required, madam? They are only question, madam, we are not entitled to get the scale, which the other, because we have been appointed under section 2010 rules. This is the only question they have raised about qualification, about nothing. We are the members, we are equal work, everything. We are not peon, not clerk, not UD assistant, not superintendent. So, my lord, I think your lordship further so far this instruction I think is not required at all.
It may be to them, lordship, but because I am also duty bound to appraise your lordship.
No, certainly, why not?
So without it, that means
you have filed your
When
affidavit.
can you come back with instructions?
lordship, I need to give require at least 1 week to 10 days time, lordship.
My lord, these people are going Old man, my lord, like just enough. Again, matter is coming, my lord.
Next time there will be no other.
Next Tuesday,
Lordship.
next Monday or Tuesday, my lord. Only instruction.
Lordship, I also have to put these things, Lordship.
No.
I need to.
Keep it part hard, my lord, because already
Yes,
your lordship.
no problem, Lordship.
M data. Then I just. I'm giving you a date.
Next Monday or Tuesday, my lord, because
Can you do it?
he is very efficient, otherwise very efficient.
Lordship can fix it on next Thursday, Lordship.
Next Thursday?
Yes, Lordship, it's on
Almost last day of the
19th.
court, my lord, vacation.
okay, on 18th, Lordship. 18th Wednesday.
1/8, no? It will come before lordship, my lord, because
Yes.
I don't know whether it'll come before me.
anyway, my lord, because since your lordship had a length, my lord. Obliged.
I appear for the finance department. I will start working. Something else. Appears for the finance department.
5.
May I present it, Lordship? Before my senior friend, so my lord, here, my lord, some time is required, my lord. It is a matter regarding the area salary, my lord, so some time is required and interdepartmental communication is going on, my lord. So, my lord.
Yes, heard, Mr. Request made by Mr. U Sharma, is a standing counsel.
Secondary Education Department. For the respondent number 1,
Secretary,
3 and 4.
Department. This is the matter after, how much time you require?
After 4 weeks, my lord.
Up to-
Date may be fixed, madam.
16th.
18th of November.
16 November.
8.
Before my learned.
Today's date fixed. We appraise this court about the time when they will pay the area salaries. The previous order will.
My last occasion, we have been directed to produce some instruction.
কিন্তু one year pass away with the
They heard, Mr. Air Medi,
PCR meeting.
PCR,
PCR meeting.
PCR. Okay, PCR Medi. Then of course. On request,
Also respondent PK Bora.
PK Bora, there is, standing counsel.
Elementary Education
Elementary
Department.
education. This matter of 2 weeks. Enable him to receive instructions in terms of the order dated 18/19.
Date meeting. Date.
This is the matter of 20 November.
Obliged.
7.
Next. So non-payment of area salary matter. You have something, my lord, inspection is required, my lord. Sometime it's required.
You have Mr.
Tell Google.
How much?
Sharma, 4 weeks, my lord.
Immediately after vacation, lots of long time. Pending.
Google and a counsel for the petition on request made by U Sharma. Then a standing counsel, secondary.
Secondary Education
Department. This the matter. After.
Immediately after vacation, lots of second week of November.
This after the Puja.
That may be fixed, no, otherwise not listed.
You want a date, please on 22nd November.
Eight.
May I please, Lordship? Well, this is a matter relating to transfer of posting, Lordship. And the two petitioners, Lordship, have been granted interim protection and others have not lost in interim. Lordship, kindly peruse the order dated 3/8/2023. Detailed order that has been passed by this honorable court. 3/8/2023.
We were direct to file affidavit in opposition. We have filed today on them. That is not actually recorded.
We have just received, we have received the copy.
Are you filing a reply?
No reply will require because this matter is relating to Lordship, law point is involved in this case, Lordship.
But Mr. M. Khan.
On Thursday, Lordship, because urgency is there.
Okay. Mr.
K. Kumar
K. Kunwar Donat,
for PNRD, standing council.
Standing Council, PNRD, Department submits that he has filed affidavit in opposition. This morning. We just will verify and just a summary report. Informed in all.
On a Thursday,
This again on Thursday will be difficult.
yes. But urgency is
17th,
70.
that Tuesday.
Nine.
In this case, not the MP in order.
Lordship, here, Lordship, we have to file a affidavit. Our affidavit will be required, Lordship. I am seeking 4 weeks time, Lordship, so that we can file the affidavit in this matter, Lordship.
Date may be fixed on after 4 days, 4 weeks.
Then we consult the petition. On request with by H. Alia and a standing called finance department. 4 weeks time is allowed to find contract.
Lordship, the education department may also file their.
Petition is also, okay. Cancel that time. The elementary education department. As well as the finance department. Praise for 4 weeks time. We find the respective contract.
It will come 15th of November, my lord.
21st. Last.
Directed the respondents, my lord, to pay rupees 900 per month lordship as to the female attendance. Mandamus was issued lordship.
Lordship.
Way back, my lord, in 2017 lordship. My lord, till now, my lord, they on this and that ground, my lord, they are taking
Lordship, if I
times.
may place my case and then my senior can, Lordship.
1 minute.
Yes,
Press 63 is the direction lordship.
Yes.
Yes, Lordship. May allow me to place my case. Lordship, here the main grievance of the petitioners are payment of honorarium to the female attendants arrear honorarium, my lord. That is the main crux. So Lordship, here finance department, now I have been informed by the finance that a budget has already been provided for that for the payment, my lords, amount of roughly 67 crores, my lords, that has been placed, my lords. Now only the finance department is awaiting the FOC proposal that has to be sent by the administrative department, my lords. That in this case, the administrative department is the health department, Lordship. Pursuant to that, Lordship, this
Yeah,
letter-
working what?
FOC proposal from the health department, my lords. They have all, the budget has already been allotted, my lord.
What is FOC?
Fixation of ceiling, my lord.
This please taking my lord, the time and again,
Lordship may hear me, Lordship. Lordship, now, pursuant to this letter, I have asked the authorities in the Health and Family Welfare Department, because the only thing is they can release the amount as per their instruction, provided they receive the SD proposal, Lordship, from the Health Department. Now the authorities in the Health Department have said that they're going to receive the FOC proposal today itself from the Director of Health Services, my lords. And upon receipt, within a period of 2 to 3, they'll try their level best to expedite the process level. Within a period of 3 weeks maximum, they'll send the proposal to the Finance Department. That is the FOC proposal, my lords, which the Finance Department is awaiting right now, my lords. That is the present situation, my lord. That is the only we have. Otherwise, the budget provision has already been created for the payment of the honorarium, my lords. Now,
Why do you need 2 to 3 weeks?
Lordship, this 3 weeks, Lordship, we won't take 3 weeks. It might be done only within 3 weeks. I'll be in a better position to maybe the order may be complied with also, my lords. I'm not sure, my lords. But 3 weeks time, they are saying they'll expedite the process. They are saying 2 weeks, and within 2 weeks also they might do it. They'll receive the FOC proposal today from the Director of Health and Services, my lord. Now, the only thing is they're asking for some time so that the court's orders can be complied with. My lords, it's almost complied with. Budget is almost there. This only the FOC proposal from the administrative department has to go to the finance department, from after which they can release the amount, my lord. That is the present status of the contempt, my lord. Pursuant to that, lordship, and whatever my learned friend has to say, lordship.
Yes.
My lord, if budget is there, lordship, my lord, 3 weeks is very, my lord, long time, lordship.
Budget is already there, but the fixation of
Lordship.
ceiling.
These are
That
the
is going to come from the health
Short time,
department.
lordship may fix it immediately after the vacation. Lordship will provide the current status as we do.
But Mr. M. Ahmed.
MH Ahmed. MH
Then is counsel for the petition. Mr. H. Alial, understanding counsel finance department,
Health and
has furnished a communication dated 10th October 2023. Written by the Undersecretary to the Government of Assam. Finance within bracket budget department. Stating that the finance within bracket budget department has made the available fund, available budget provision through supplementary demands for an amount of rupees 6720.00 lakhs. Stop. It further states that the proposal for fixation of ceiling has not been received in the finance department from the concerned department. Stop. Para. On further instructions, H. Alia, the understanding council finance department submits that they are expecting the fixation of ceiling proposal from the Department of Health and Family Welfare within a period of.
Actually, they're asking for within 2 weeks. They can say they said they'll forward to the finance department.
And after that, the directions passed by this court would be complied with. Recording the submission made by the learned standing council finance department. This matter again on 14th November. Communication dated 10th October 2023.
Lordship, item number 17, Lordship. My name is recorded, Lordship.
Yes.
Same issue, Lordship. Item number 17.
Yeah, I appear for the respond number to me, item 19 year old.
Mr.
A Das.
Leonard.
Respond number 2 year old for in item 19.
Which please respond number 2.
Respond number to the chief secretary. Lord.
You are the government advocate.
No, year old.
Leonard counsel. Oh, okay. Contempt appeals for the respond number 2. In contempt case number
452 of 2023.
452 of
2023.
2023.
Much obliged.
Obliged.
20, part hearing matter.
What was this about?
In this matter, your lordship will recall, in the last week, the arguments were concluded. I was just supposed to submit a written argument.
Yes.
And that we have prepared.
Lordship, for finance department, I was informed that we'll be filing the written submission by tomorrow morning. Lordship, may I just, we have it's ready, my lord. It's just final touching it. We can submit a copy by tomorrow, my lord. Lordship.
So Lordship can close it, my lord. But I told you, then the senior counsel assistant by Mr.
Yes, Mr. Kamal.
Is Vishwakumar, then the counsel for the petitioners. Also heard Mr.
Solia, Lord.
Mr. H. Alia, then the standing counsel finance department. For respondent 5. Who appears for the agriculture department? MSR Boral, then the standing counsel agriculture department for respondents 1 to 3. Stop. Hearing concluded, judgment reserved. You've supplied a copy?
I've already.
Okay. Finance will give you the copy. Don't give the file today. You keep it with you after that.
Item 26 to 33 of supplementary list. Hearing.
May please, Mr. Lord, I'm appearing for 26, 20, 29, and then 29 to 33, my lord. All the
29 to 33.
yes, ma'am. 26, 29.
You are Mr.
BD Decca.
BT Decker.
My lord,
And 27, 28.
27 and 20.
28 RM Decker. And 27. Patwari.
Yes.
I appear for the IOC in these matters. Well,
Oh.
may I just indicate the why these large number of cases? Item numbers 27 and 28 are two writ petitions where a selection has been put to challenge. Selection and appointment has been put to challenge by one by Mr. Arandeka's client and the other one by Mr. Ken Chaudhary's client. There they question the selection itself
Process of selection.
in respect of two of the candidates. Now, once that was put to challenge, and in the meantime, there were certain complaints also regarding this election. And we conducted an internal inquiry. In the inquiry, it was found that there were certain anomalies. Based on the findings of the preliminary inquiry, we have terminated some of the candidates in respect of whom some anomalies were found. So the other writ petitions, that is item numbers 26, 29 to 33, are these persons who were serving on probation, whose services were terminated, and those are under challenge by my learned friend Mr. Tek. So these are the two groups basically. Item numbers 27 and 28 are challenge to the selection and appointment, and 26, then 29 to 33 are challenge to the orders of termination of the probation. In a nutshell, one of that is the.
So if 27 and 28 is answered in the affirmative, then everything goes. Correct.
Not really, my lord. Not for the others, my lord. Because
The
27.
selection process is under challenge, isn't it?
Not the
27
entire process in respect of.
Okay, in respect of two candidates.
Basically, my lord, 27 and 28, the challenge is the appointment of the writ petitioner in item 26.
Okay.
So once he was terminated, during the pendency of the writ petitions, these 27 and 28, we terminated them. So that termination is under challenge again.
Sure.
So that's how these are clubbed together. So depending on the.
So who's arguing first?
Item 28, we can
Where is Patwari? Is he adopting your submissions?
basically the challenge are
Same.
Essentially, well, perhaps 27 and 28 will have to be heard first.
Correct.
And only because the other writ petitions should be to some extent dependent on the outcome of 27 and 28.
27 is.
Item number 28, my lord.
And in fact, in 27, I think we were asked to file the affidavit.
in item number 27 and 28, we were directed to file an affidavit clarifying one particular factual issue, and we have already filed that affidavit, and I think that is also on record.
By respondent 6,
IOC.
Find it.
What is the respondent number in that case, Rahul Das? Where have you filed? Where you filed?
Respondent number, it's an affidavit filed by the respondent number 124. It was filed yesterday.
by 1,
Respondents 1 to 4 in item 27.
it was filed yesterday.
Malo. A small clarification that was required. We have clarified the position.
One affidavit is here, says respondent 2 to 4.
That will be in item number 28.
In 8082.
That is 16 February 2023.
No, it's an affidavit filed yesterday.
On 9/10/2023.
On 9th of October.
Correct. Yes.
In item 28, my lord. Item 28, my lord. In this matter, my lord, we have challenged the selection and appointment of the respondent number 6, my lord.
Where's the advertisement first?
Yes, my lord. Advertisement, my lord, will find it page 27. This is the advertisement, my lord. My lord, that post code 202, the issues involved relates to code 202. The post name is Junior Engineer Assistant 4, PNU, for Guwahati Refinery, my lord.
Guwahati.
Yes. So there are 3 posts, my lord, 2 for unreserved and 1 for OBC. And I'm the OBC candidate, my lord. Then, my lord, kindly turn to page 29.
Yes.
Page 29, that capital B column, qualification and experience criteria.
Oh.
For junior engineer, that my lord will find at Roman 2. The qualification is, my lord, 3 years diploma in mechanical or electrical engineering from recognized institute, university, and boiler competency certificate, first class or second class, provided that in case of non-availability of sufficient number of candidates meeting the prescribed parameters, candidates possessing the following qualification may also be considered. I fall under serial number 2, my lord. The BSc, Physics, Chemistry, Maths with apprenticeship training in boiler trade. And my lord, area of experience, my lord, will find it page 29, the previous page. For candidates possessing diploma, matric with ITI, fitter and holding boiler competency certificate, or BSc with boiler apprenticeship, no further experience shall be required. So these are the criteria, my lord. Now, my lord, kindly turn to page 33. There, lords will find a age limit relaxation, my lord, in respect of age, G, my lord. That is serial number 2, meaning serial number 3, my lord. Relaxation in age up to 5 years for SC, ST and 3 years for OBC non-creamy layer. Candidates considered against reserve position will be allowed. Then, my lord, kindly come to serial number 8. Period of apprenticeship training under the Apprentice Act 1961-73 as amended in an industry covered under the experience criteria notified in this advertisement relevant to a post will be considered for relaxation in age. In our submission, my lord, we are entitled for 5 years of age relaxation, my lord, 3 years for OBC and CL category, and 2 years for my apprenticeship training.
Where is that? Does it prescribe any age limit?
Age limit is, my lord, will find at serial number 2.
That's fine.
Minimum 18 years and maximum age shall be 26 years for general candidate as on 30/9/2021. This was the date, my lord, for submission of application forms.
Then for OBC, serial number 3.
Serial number 3 is OBC, my lord.
And what is there in 8?
My lord.
Serial number 8.
Serial number 8, my lord, prescribes, my lord, if I done my apprenticeship training, my lord, that year will be counted for my age relaxation. So,
Oh, that particular year.
yes, ma'am. That particular.
Yes.
Kindly turn to page 26, my lord. This is my apprenticeship certificate. I am entitled for 2 years of age relaxation for having apprenticeship training at page 26.
Yes.
May I read, my lord? This is a certified that Prasang Kumar, apprenticeship training number so and so, has completed 24 months apprenticeship training as trained paid apprentice broiler attendant under Apprenticeship Act 1961-73 at Indian Oil Corporation Limited, Guwahati Refinery from 26/2017 to 19/6/2019. So I have completed 2 years of apprenticeship training, and as per clause 8 of clause G, my lord, I am entitled for this 2 years relaxation ban for having apprenticeship training. And my lord, along with the 3 years is relaxation for OBC, my lord, being an OBC category candidates. Then, my lord, we participate in the selection process. And after the selection process, my lord, I made an application to RTI regarding my marks. And that was furnished to me on 14/12/2021. My lord, will find at page 37. This was furnished to me, my lord. My lord will find a reply at page 37. The marks scored by me was 79. And my lord, at the same time, I was furnished with the list of selected candidates. That, my lord, will find at page 39. Serial number 1, my lord, find the name of Pranav Pathak. He is the respondent number 6 and writ petition and other writ petition, my lord. He is belonging to OBC NCL category and he obtained 73 marks. 6 marks lesser than me.
Is the response number?
6, my lord. 6, no? Response number 6, my lord. Therefore, my lord, kindly turn to page 51. This is the reason why I was not selected. The reason is recorded here, my lord. May I read the entire letter, my lord. Page 51, annexure I. May I read, my lord?
Yes.
This is in reference to the above mentioned PG filed by you regarding candidate selection at Indian Oil Corporation Limited, Guwahati Refinery. We have reviewed all your complaints stated in the PG, and following is the response from our end. In reference to age relaxation and experience required for the post, code 202, the basic requirement of educational qualification area of experience state as follows. For candidate possessing diploma matric with ITI fitter and holding boiler competency certificate or BSc with boiler apprenticeship, no further experience shall be required. Further, as per clause G8, period of apprenticeship training under Apprenticeship Act 61/73 as amended in an industry covered under the experience criteria notified in this advertisement relevant to a post will be considered for relaxation in age. As per clause J5, admit cards for written test will be issued to all prima facie eligible candidates on the basis of the details furnished in online application form and submission of application fees applicable for unreserved EWS and OBC NCL category candidates. Scrutiny of documents submitted by the candidates will be carried out post-written test. Only those candidates will be considered called for the next stage, that is skill proficiency physical test, who are shortlisted on the basis of written test. Refer clause J7 and B meet the notified eligibility criteria upon verification of documents sent submitted by the candidate and other parameters. After the written test, scrutiny of documents was done, wherein it was observed that Mr. Prasang Kumar, this is a petitioner, my lord, belongs to OBC NCL category. As per the experience criteria and age relaxation mentioned under clause G, of the advertisement, Sri Prasant Kumar was eligible for age relaxation of either 3 years against his OBC NCL reservation or maximum 2 years age relaxation against boiler apprentices certified as allowed by the system. So we have agreed by this observation matter. We are entitled for 5 years, but by way of this letter, we inform that we are entitled only for 2 years, either only for 2 years for OBC or 3 years for OBC and 2 years for having the apprenticeship training certificate. It is to be noted that all the age limitation relaxation mentioned in clause G of the advertisement are distinct and different from each other. Hence, benefit of candidates are extended accordingly. Clause G3 of the advertisement dated 21/9/2021 provides relaxation in age up to 3 years of OBC and NCL candidates. However, even after providing the age relaxation of 3 years, you are overaged by 5 days. Hence, your candidature was summarily rejected. The respondents, my lord, have filed their affidavit in our matter, my lord, on 16/2/2023.
Yes.
The serial number 61. Affidavit filed by the respondents number 224.
Yes.
In their affidavit, my lord, kindly turn to page 63, para 5. It is submitted that the candidature of the petitioner was erroneously denied due to certain discrepancies, irregularities in the recruitment process, which came into knowledge of the answering respondents pursuant to an internal inquiry conducted by the respondent number 5. Then paragraph 6, it is submitted that acting upon the complaint letters dated 2/2/2022 and 26/6/2022 sent by the petitioner to the respondent number 5, an internal inquiry was conducted by the respondent number 5 pertaining to the instant recruitment process. That the said letters dated 2/2/2022 and 26/6/2022 are already marked as Annexure G and H respectively at page 47 to 50 of the instant writ petition. 7. It is submitted that on the basis of the internal inquiry, certain recommendations have been put forth by the respondent number 5 inter alia, observing that the respondent number 6 was erroneously selected, appointed to the said job post. I crave leave to refer to and rely upon such recommendation at the time of hearing if necessary. Then paragraph 11, my lord, the next page. It is submitted that implementation of the recommendations have commenced, which amongst others will include termination of the respondent number 6 from the job post and reselection of the suitable candidates as per procedure from rejected candidates, which includes the petition. So, my lord, as per their affidavit, the respondent number 6 was erroneously selected. Now, my lord, my prayer is we may be allowed to continue in the selection process, to participate in the selection process from the skill test. Now, the next step was skill test. So
After the written test
yes, ma'am.
is the
Skill and proficiency test. Ma'am. So this is my humble submission. They have stated that he was erroneously selected, my lord. So my
Please, your lord. My lord, I am representing petitioner in item number 27. Actually, will kindly take up WPC 1373.
yes.
Yes, that should be taken up WPC 1373. Yes. And it issues are identical, same advertisement. And look, there were 3 posts for the post. My lord, 2 were for general, 1 was for OBC, my lord.
Let
And-
us see that condition again in the age limit.
My lord.
Yes, page 33.
Yes. Clause G, my lord.
Yes.
Yes. More gathi dikhi toka. More gathi dikhi, more gathi dikhi. My lord, this clause G prescribes for age limit and age relaxation, my lord. G3 provides for age relaxation of 3 years.
You're also OBC?
Yes, I'm also OBC.
The next. You're the next one.
Maybe like. জানলে প্রথমখন যেখানে ফিরে ফিরে না পরিশ্রম দিতে সাপ্লিমেন্টারি না প্রথম কথা তাহলে
So according to this, 3 years relaxation for OBC,
yes,
and in Deca's case, 2 years.
same my lord, I am also 2 years plus my lord 8 and 10 also. Maximum relaxation of 1 year is will be given to candidates possessing boiler competency certificate. So
But may I clarify the position? The ground on which they were rejected was that they will not be entitled to both, either 3 years or 2 years. So that is how their candidature was rejected. Later on, it was found that it is not either of the two. It is both 3 plus 2. And if that is taken into consideration, their candidature could not have been rejected. So that is what we have now said, that that was a mistake we made. And had that mistake not been made, these two petitioners in item numbers 27 and 28, since they have got higher marks, the respondent number 6 could not have been selected and appointed.
How many posts were there? 1.
OBC 1,
OBC 1.
general 2.
So now, if it proceeds, now we have already terminated the respondent number 6, since that error was detected. Now they will have to proceed to the next stage of the selection. That is what is known as the SPPT test. So after that screening process, either of these two petitions may be selected, since they were wrongly rejected at the threshold based on this incorrect interpretation of those two clauses.
So they are like conceding to the extent that we are erroneously rejected. I mean, just 2-3 pages, my lord. After I passed my written examination, as I was not allowed to go for the next level, I also applied under RTI. Lordship will kindly come to page 47 of my writ petition, Annexure J. Page 47, my lord. I secured 93 marks as per their reply under RTI. Then at the very next page, that is page 48, Annexure K, they have given me the grounds for rejection that I am overaged by 7 months, 6 days. Now, my lord, pursuant to their me 28th November 2025. November. My lord, the department has filed a counter affidavit, and to that I have filed one reply. And there is a judgment of this honorable court which have annexed to that reply, wherein the department has admitted and this honorable court has recorded that for OBC same post was advertised in that case also, and the same mistake was carried out. They were giving either relaxation, age relaxation for OBC or for the experience. Now, when the court took up the matter, there they came up with a stand, no. Actually, that is a mistake. As per the direction of the Honorable Supreme Court, my lord, it is 3 plus 3. 3 years for age relaxation for OBC and 3 years for experience. That order I have annexed, my lord. Procedural will kindly take up my reply.
Reply.
Yes, affidavit in reply. It starts from page 64, it's running page 64. No?
Yes.
And the order is at page 71. Order dated 26/2/2016. Has your lordship got it?
Mm.
My lord, the second para, according to the petitioner, may I read it, my lord?
Yes.
According to the petitioner, he belongs to the other backward classes. He had also undergone apprenticeship training from Guwahati Refinery. An advertisement dated 26/11/2015 was issued by the Guwahati Refinery for recruitment of non-executives in the said refinery. Petitioner is interested to compete for the post of junior engineering assistant, as is the interested, my lord. Postcode of which was so and so. In terms of the said advertisement, a candidate is required to be within the age group of 18 to 26 years as on 1/11/2015, relaxable by 5 years for SC/ST candidates and 3 years for OBC candidates. Petitioner is now aged about 32 years, and despite being an OBC candidate, he would be overaged as per the said advertisement. However, petitioner would be entitled to further age relaxation of 3 years on account of his apprenticeship training. It is submitted. It is further submitted that the petitioner has submitted a representation dated 28/12/2015 before the Chief Human Resource Manager, Indian Oil Corporation Limited, with a prayer to relax the upper age limit in his case and to allow him to participate in the recruitment process for the appointed post. Learned counsel for the petitioner submits that the written test pursuant to the said advertisement scheduled on so and so. Mr. Deka, learned standing counsel submits that the petitioner is overaged by more than 3 years, and as he would be not entitled to age relaxation on account of apprenticeship training, which is only available to the relevant trade. From a perusal of the advertisement, it is seen that it was issued on 26/11/2015, and the last date for submission of the application was 15/12/2015. Petitioner submitted representation for age relaxation only thereafter on 28/12/2015. The writ petition is silent as to why the petitioner did not approach this court before the last date of the submission of the application. Writ petition has been filed on the same day, that is on the day of filing of representation, so and so. While the court does not appreciate the conduct of the petitioner in approaching the court at the 11th hour, nonetheless, the court is of the view that since a representation has been filed before the reference number 4, it would be open to the said respondent to consider the said representation in accordance with law and to take necessary decision thereafter. Let such consideration and decision be taken within a period of 7 days from the date of receipt of the certified copy of this order. Whatever decision is taken should be communicated to the petitioner. Now, my lord, that decision is taken. That will kindly come to the next page, page 73. There, my lord, his case was again rejected, and the second petition was filed. My lord, the second para in the order, has your lordship got it? At page 73. In the order dated 4/1/2016, this court has clearly indicated that it did not appreciate the conduct of the petitioner, notwithstanding the same. Such observation, the respondent number 4 was given the liberty to consider the representation of the petitioner for relaxation of upper age limit. In terms of the above order of this court, communication dated 14/1/2016 has been issued. Relevant portion of the communication dated 14/1/2016 reads as under. Madam, this is the stand of the department. From the representation filed by you, as well as from the scrutiny of our records, it appears that you had undergone apprenticeship training in the Guwahati Refinery in the trade of broiler attendant with effect from so-and-so period to so-and-so, that is a period of 3 years. Moreover, you belong to other backward classes. As per the advertisement dated 26/11/2015 issued by the Guwahati Refinery for recruitment, inter alia, to the post of junior engineering assistant, power and utilities, the maximum age as on 1/11/2015 was 26 years. Kindly mark this next word, which was relaxable by a period of 3 years for OBC candidates. Further, as per the relevant guidelines issued by the Honorable Supreme Court of India, an apprentice trainee is entitled to relaxation of his age by period equivalent to the period of apprenticeship training undergone by the said candidate. Therefore, you are entitled to relaxation of 6 years That is 3 years on account of your apprenticeship training and 3 years on account of your belonging to OBC category. So, my lord, way back in 2015, this position has been made clear. And the Supreme Court's order they are referring to, and the last occasion we have given, that is, my lord, reported in 1995 to SCC, UP State Transport Corporation versus UP Parivahan Sangam.
Who is that?
My lord, we have already given 1995 to SCC.
It's annexed here.
No, it's not annexed. We have given a loose copy, my lord.
Where?
To SCC, page 1. My lord, just small break, I'll read and hand it over to your lordship. Hello, one copy. And 1995, volume 2 SCC, page 1. UP State Road Transport Corporation versus UP Parivahan Nigam. Lordship will straight away come to page 6, para 12, madam.
Yes.
Yes. In the background of what has been noted above, we state that the following would be kept in mind while dealing with the claim of trainees to get employment after successful completion of their training. 1. Other things being equal, a trained apprentice would be given preference over direct recruits. 2. For this, a trainee would not be required to get his name sponsored by an employment exchange. The decision of this court in Union of India versus N. Harigopal would permit this. 3 is important for us, madam. If age bar would come in the way of the trainee, the same would be relaxed in accordance with what is stated in this regard, if any, in the service rules concerned. If the service rule is silent on this aspect, relaxation to the extent of period for which the apprentice had undergone training would be given. So, my lord, for being an OBC candidate, 3 years, and for undergoing training as an apprentice, that amount of year time taken would be relaxed now. So, my lord, in our case, as an OBC, we are entitled to relaxation of 3 years, and we have undergone training of apprentice for 2 years. So 3 plus 2, 5 years relaxation we are entitled to. But despite having secured the highest mark, that is 93 in the written test, I was not called for the next level of selection. And then at that stage, we filed an RTI. We were provided with the information that you were overaged by 7 months, 6 days, so you were not called. That's why we are before this honorable court, my lord, highlighting our grievances. And in their supplementary affidavit, in my case also they have filed, that they have admitted their position and they have said that we have wrongly deprived of our, my lord, participation in the next level. So, my lord, I humbly pray that lordship will allow this petition and allow us to participate in the skill and proficiency test. And my lord, I can point out my OBC certificate and my other requirements if your lordship want. I have fulfilled the other eligibility criteria. Page 21 is my PCM, my lord, mark sheet. Page 21 of the petition. This is my mark sheet, my lord, BSc. Major course was physics. The requirement is, my lord, physics, chemistry, and maths. So my major course was physics, my lord, on the top. Then, my lord, general subjects, chemistry, mathematics. And at page 22 is my OBC NCL category certificate. And at page 24 is my apprenticeship certificate. Down below, training duration 12 May 2017 to 11 May 2019. Has your lordship got it? So, my humble submission before your lordship is that, in view of the decisions of the Honorable Supreme Court as well as the decision I just read over passed by this Honorable Court, we are entitled to, my lord, relaxation of 5 years, 3 years for OBC and 2 years for undergoing this apprentice training. So we could not have been, my lord, restrained from participating in the entire selection process, but that has been done and they have admitted also in their affidavit. Now, my lord, from the stage where we have been deprived, they will hold the selection and allow us to participate and select that man for the post OBC. That is my humble submission.
You got 93 marks.
Yes, I got 93. I have applied.
The class was
79.
79.
79. And the
And the-
selected candidate got 73.
In fact, my lord, if your lordship comes to the prayer made in the writ petition,
Which writ petition?
Rahul Das, that is 27,
Item 27.
item 27. For all practical purposes, the first prayer, this is at page 16.
Yes.
In this petition, the respondent, selected candidate is a respondent number 5. In the other petition, he is respondent number 6. The first prayer is, why certiorari shall not be issued directing the respondent authorities to cancel the appointment of the respondent number 5. That we have already done. We have already terminated. So for all practical purposes, prayer A has become infructuous.
Yes, they will bring that.
So that relief they have already got. Now the second prayer is a direction to appoint. That obviously your lordships won't or cannot do for the simple reason there are two persons in the fray who become eligible. The petitioner in item number 27 as well as the petitioner in item number 28. So naturally they will have to face the next stage of the selection, that is the SPPT test. And whoever comes out successful will be appointed.
We are prepared.
So
That is our prayer.
it is not that your lordship can direct appointment because there is only one post. Only one out of these two can be
Yes.
selected. So, and so far as the challenge made on the merits of the case is concerned, we are admitting the fact that they are entitled to 3+2. And therefore, their rejection on the ground of being age barred, overage, goes. So, if that be the position, my lord, these two writ petitions, I think, can be disposed of by holding that so far as the first prayer is concerned, it has become infructuous. And so far as the second prayer is concerned, they will have to now face the next stage of the selection. And whoever comes out successful will be appointed.
Yeah, that's all
Yes,
right.
yes. They have terminated the private respondent, that is admitted, my lord, but they have not called us for the next level of selection. So that
Since the writ
The
petitions
only
are
issue
pending,
is
Yes.
if I dispose this 26 and 27,
27 and 28.
27 and 28.
And the other batch has to be heard at, because there, the challenge is, they are saying that we were serving on probation. You have terminated our service. So they are saying that you could not have terminated without giving us an opportunity of hearing. There, your lordship will have to go into that entire law relating to termination of probationers, whether they would be entitled to the benefit of natural justice or not. Your lordship will have to go into all the, that will require some amount of hearing. These two writ petitions can be disposed of saying that first prayer, they have already got the relief. So far,
Will it not jeopardize the case of the other writ petitioners?
the other writ petitions will have to be heard at length. There, your
No, no,
lordship.
supposing I dispose these two, will the judgment not jeopardize the case of
May
the
I
other?
just-
Item 26.
may I just submit my point? Our prayer is that we are assailing the selection process. We have been illegally deprived. Now, my lord, if your lordship allows our writ petition, that means the selection of the private respondent was not according to the law. If the selection goes, my lord,
It will have
automatically-
some bearing on item 26 at least, that is for sure.
That is what I'm asking.
26 becomes infructuous.
if my lord, the selection was not as per law, the appointment, my lord, consequently,
There, the challenge is on a completely different ground altogether. So your lordship will have to go into the law.
27, 28 is a simple issue.
yes.
You are admitting something has
Admit.
gone wrong. And they are also saying, and as per the advertisement, they're entitled to 5 years relaxation. So therefore, they should be allowed to proceed for this, what you call skill and proficiency.
The next level of selection.
As per the advertisement.
That's fine. Supposing I pass that order here, Will it not jeopardize the case of the other petitioners?
Not all, only item 26.
I don't think this.
Because there are several different categories of posts. So far as this particular post is concerned, only item 26 gets affected. Other writ petitions, there is no problem.
So 26.
Because he being the beneficiary of this illegal
Ah.
selection, well, if the selection goes, the appointment automatically goes. It's a consequential action, man. Obliged.
In fact, my lord, my friend appears as the respondent in in item 27 and 28, my lord. But I'd just like to point out two things, my lord. I am the petitioner in 26, my lord. So my appointment is challenged in 27 and 28, my lord. You know, just two things I'd like to point out, my lord. While this issue was under consideration by this court, they had already terminated me. So while the matter was sub judice, they sort of took a different stand and said that, yes, maybe we were wrong and therefore we are terminating you. Now, while doing that, my lord, two very pertinent issues, my lord. First of all, my lord, in these two writ petitions, they had filed an affidavit contesting the claim initially that they are not entitled to the cumulative age relaxation. Then they made a volte-face and they filed another affidavit, the same deponent, and he says, no, they are entitled to a cumulative age relaxation. Now, there again, my lord, if your lordship sees the age relaxation clause, there's a clause which is G9. G9, if your lordship takes up. Now, this apprenticeship certificate can be used for two purposes. It can be used as an experience certificate and it can also be used for age relaxation.
That's what.
G9 makes it clear that you can't use it for both. Now, there is no material on record to show whether this particular apprenticeship certificate has already been utilized for the purpose of meeting the experience criteria.
No. G9.
G9, if I may read, my lord. Further period of apprenticeship training in an industry covered under experience criteria notified in the advertisement relevant to a post may be considered as experience. Then, my lord, this is very important. However, in such cases, relaxation towards age shall not be available.
But then you read the advertisement.
My lord, because for the experience, if your lordship takes up B,
Where is that experience part?
my lord, internal page 2 of that advertisement, my lord. Page numbers on the bottom, my lord.
Yes.
My lord, finds for junior engineering assistant PNU, that is the concerned post, area of experience, the third column, the lordship finds that for candidates possessing diploma metric and holding boiler competency certificate or BSc with
You are reading from which
Page number 29.
page 20.
Page 29.
Page 29 of item 27.
Item 27.
Item 27,
it
page
says
20.
no further experience shall be required. Correct.
Yes.
No further experience.
No further experience. Now, clubbed with this, if your lordship takes up G9, G9 is basically saying that this particular apprenticeship certificate, you can use it for an experience and you can also use it for an age relaxation. But if you've already used it for experience, then it cannot again over and above that be used for age relaxation again. Now, there are no materials to show whether they had.
But Learned Counsel, you're not appearing in 27 and 28.
But this has a bearing in 26.
But, since you are not appearing, you can
I'll address that argument when I argue 26, my lord. For now, my friend can take over.
Yes.
Yes. I have to say the same thing what he has argued. I am appearing for private respondent. Item 27 and 28.
Both.
In what he has said, it is I have to point out just this thing. That clause G8 specifically mentioned that period of apprenticeship training so is an industry covered and experience criteria notified is relevant to a post will be considered for relaxation of age. And 9. Further, period of apprenticeship training is an industry covered so relevant to a post be considered as experience. However, in such cases, relaxation towards age shall not be available. This is important. If the certificate is used as an experience for applying the post, then the certificate similarly you cannot be used as a relaxation of age. Lordship, for this I have to produce one judgment of the our High Court. Lordship, which is decided by SRPS. Where is it is clearly mentioned. Paragraph 8 and 9 is the more relevant. Okay.
Yes.
This is one of my aspects, and I have to submit, draw your attention in another matter of it, another thing that
1 minute.
and another aspect I have to submit, Lordship, if these two petitioner is entitled for +2 benefit, then
Age
age
benefit.
benefit,
Mm.
then I would have been selected and appointed under general category. Since I have got more marks than the selected general
But that
category
is not
candidate,
that is not the issue involved in
then
this.
not actually involved with it.
That you'll have to fight for your own.
So in that issue, I have not to be submitted because I have got more marks than the selected general category candidates. That is why I have to brought into notice this code that if the petitioner is entitled for 2 years relaxation, I may be entitled for 2 years relaxation. Then I am eligible for appointing as a general candidate because I have got more marks than the selected general candidate. And at the considering age relaxation, I have just 26 years, 5 days. What is the requirement, the criteria of the selecting candidate? So that is why I'm pointing out this point also.
Chowdhury, what do you say on this?
This judgment opens up a new horizon altogether.
Yes.
Now, if we go by this, and there's one judgment of my Lord Justice Ujjwal Meena, which says that they will be entitled. This judgment says that they won't be entitled. Then again, perhaps they're being apparently, I have not gone through both the judgments thoroughly. In that case, perhaps again, we have to examine whether this matter requires a reference to a larger bit. Because now it might be a case of two conflicting judgments. I was totally unaware of this judgment of my Lord Justice Jothanguma. Here, apparently at para 10, it has been held that both the benefits, if you have taken the benefit under the experience clause, you cannot take the benefit of age relaxation.
What does the other judgment say? Let us go through.
The other judgment
That was in the earlier petition, correct? In Decca's case. It was in your case. Was it, is it your case?
Yes. In
That
item,
judgment?
yes, in item 27, I filed my reply. Why not? My lord, in our case, this judgment is relied upon, this honorable court has relied upon a judgment of the honorable Supreme Court, my lord. That 1995 PSCC. I have one small clarification to make, my lord.
This creates some amount of confusion for you. What happens is, well, if your lordship.
Yes.
Minor Justice Bhuyan's judgment relies on the Supreme Court judgment. And if your lordship takes up the Supreme Court judgment for a moment. And if your lordship comes to para 12, subpara 3. If age bar would come in the way of the training, the same would be relaxed in accordance with what is stated in this regard, if any, in the service rules concerned. If the service rule be silent on this aspect, relaxation to the extent of the period for which the apprentice had undergone training would be given. Essentially, what is the Supreme Court is trying to say here is the other relaxations that you get are under the rules or some statute, like for example, of OBC or a SC or a ST candidate. These are entitlements of a reserve category candidate. But since this is an additional experience that you have acquired under the Apprenticeship Act, over and above whatever you have got, you will get this additional benefit of age relaxation. And this judgment has been relied on by my Lord Justice Bhuyan.
Yes.
However, my Lord Justice Zothan Kumar's judgment, this judgment is not even referred to. So perhaps had this judgment been placed before my Lord Justice Zothan Kumar, that aspect would have been gone into. So to that extent, my Lord Justice Zothan Kumar's judgment becomes sub-silent. So therefore, perhaps that aspect will have to be examined, whether this would require a reference to a larger bench on this issue.
Whether in this Supreme Court case, whether that experience part was also there?
No, I don't think. Those aspects were never raised, my Lord. It is only the question of relaxation of age for people who have undergone apprenticeship training.
Correct.
So whether it will run parallelly or separately, that aspect never even came up before the Supreme Court. Whether cumulatively they will be entitled or not, that aspect was never even raised before the Supreme Court.
Because your advertisement is very specific. It says either age or experience. If you
In fact, originally, that is how it appears. That is how the authorities had originally rejected. However, once this issue was raised, then all these aspects came to light, and the matter was referred to initially for an internal examination, and thereafter it was referred to the vigilance. And vigilance made a recommendation saying that no, they will be entitled to vote. And once that recommendation came, and they recommended taking action. Since had these two persons not been rejected at the threshold, they would have been entitled to participate in the rest of the selection process. So that is how we ended up, based on the recommendations of the vigilance, we terminated.
Then why not you study this matter and come back?
Ultimately, I think the entire matter requires, all of them have to be heard together.
Yes.
And it will require some amount of hearing. And this aspect also requires some examination. Now, whether,
That's what,
because
after the new judgment has come in.
yes, my Lord Justice Zothang Kumar's judgment, this is a judgment I'm taken by surprise. I was not aware of this judgment. But one thing is for sure, my Lord, quickly glance through. This does not even refer to the Supreme Court judgment.
No,
So
it- it
to
does
that
not.
extent, it is subsilent. So again, that requires examination, whether your lordship would entirely, because your lordship is aware of the law. If a judgment is parent curiam or sub silentio, your lordship is left with two options. Either to completely ignore it, saying that it is sub silentio, it does not refer to the Supreme Court judgment or the earlier judgment. This does not even refer to my Lord Justice Bhuyan's judgment. So one option is for your lordship to ignore it completely, saying that this is a judgment which has been rendered sub silentio because of this, or else holding that there is a conflict between these two judgments, your lordship has to, the only option is to place it before the Chief Justice so that it can be referred to a larger bench. So that aspect will again require some amount of examination.
Then maybe the whole matter has to be heard.
I don't know whether it will be possible because in all probability, next week, entire week will be declared as a motion week. We are hardly left with 4 working days. After, if my friends agree, we can fix up a definite date after the vacations, and in the meantime, we'll all examine these aspects also.
Well, only one my lord aspect I want to, my lord, bring it to your lordship's notice. At page 29 of my petition, page 27. Page 29, item 27.
Yes.
My lord, our post is, my lord, at serial number 2, junior engineer assistant, power and utility. And lordship will kindly come to the third column, area of experience. For candidates possessing diploma, metric with ITI fitter, and holding boiler competency certificate of BSc with boiler apprenticeship, no further experience shall be required. Now, my lord, there is no requirement of us having any experience because there is no way prescribed that this is the, if your lordship sees for the other column, minimum experience is prescribed. So if we are holding that certificate, the question of experience doesn't arise. So we are using this certificate as a age relaxation certificate, my lord.
No. Here it says no further experience shall be required.
Yes,
There's
but what is
something-
the minimum experience required? Where it is stated, my lord? What
There's
is the
something that-
experience required where it is stated, my lord? In respect of others, if your lordship kindly peruse the above or below other posts, minimum experience is required. That's serial number 1, minimum 1 year post qualification experience. Serial number 3, minimum experience is prescribed. In our case, where it is.
For candidate possessing diploma.
Exactly.
Minimum 1 year diploma.
Exactly. For diploma candidates in our post also, minimum qualification. But what is the minimum experience required for us? It's nowhere stated, my lord. So, my lord, we can, the moment we are possessing that certificate, the question of experience in our case does not arise, and we can use the certificate for age relaxation. That is my humble suggestion. Because some minimum has experience is prescribed like in other cases, my lord. Nowhere prescribed.
The other problem is, this is not an issue which is pleaded. It is just during the course of the hearing, it has come out. This is not a pleaded case as such.
Then you give a convenient date, we'll fix it on that.
Second week of November,
Second week of November.
9th.
Heard Mr. J. Patwari, counsel for the petitioner in WBC 1 of 2022. Also heard Mr. R.M. Decker, learned counsel for petitioner in WC 8082 of 2022. And Mr. B.T. Decker, learned counsel for the petitioners in the other writ petitions. Also heard Mr. I. Chowdhury, learned senior counsel. Assisted by MST Singh for the Indian Oil Corporation, and Mr.
B Fukan.
P. Fukan, learned counsel for the private
Respondent.
in WC 1373 2022 and 80882 of 2022. Is the matter?
Can it be on 16th? 16th of November.
Okay, 16 now.
Deep
Can it be, my lord, since it has already been listed at the top of the list, can that same column continue?
At the top of the list.
21 of daily list hearing.
His lordship, Mr. R.P. Chaudhary is on lakes in book number 12, lordship. So might we pass over for the time being?
What is it?
Will we pass over for the time being, lordship?
Time being,
Or
look at the clock.
yes, lordship, that on lordship, we fix it on Thursday, lordship. Yeah, after.
This was,
I leave it to your lordship.
oh, we have it after the puja. Is it? Okay.
Yes,
But Mr. S.C. Biswas, when it comes to this on request made on behalf of Mr. R.K.D. Chowdhury, letter of the SGR. You want a date or just after the puja?
After puja.
Please, after the puja.
oblige.
Development.
23.
May I please, your lordship? Lordship, the matter here pertains to the non-payment of salary as well as regarding irregular appointment of the petitioner, lordship. It's a hearing matter. Lordship,
What is our representative?
lordship, mainly education is the main.
Education.
Education is the main.
You, Sharma, you are playing?
Yes, ma'am.
Education. Secondary education.
Secondary education.
You are prepared?
Yes, ma'am.
You file your affidavit?
Yes, we are fine.
Yes.
Lordship, the petitioner was appointed to the post of assistant teacher in Borajal High School, lordship. And he has been appointed in the year 1998, lordship.
Page.
Lordship, the appointment we have not annexed here, we couldn't get it, but that is reflected in the impugn order also regarding his working, lordship. There's been in the lordship takes up page 34. Page 34, again. Findings part, lordship.
1 minute. Yes.
The findings part, the petitioner, Sri Merunjiti Borwa, has joined in Borajal High School as an honorary assistant teacher on 2/11/1998.
Yes.
That is the regarding the appointment of the petitioner, lordship. Then, my lord, in the year 1999, there was a notification for the appointment of the students of the teachers of. Actually, I'll take you to page. It will be clear. Page 18 is the notification. 18 Lordship. Is the type copy regarding the benefit of reservation, Lordship. May I read, Lord? In supersession of government notification so-and-so dated 8/4/97 regarding 10% reservation quota against the vacancies in LP school for the works of LP school teachers, the government in education department decided to extend the benefit of reservation to the sons or unmarried daughters of retired teachers from primary to secondary level teachers within the approved quota of 10%.
What is
According
this
to my-
10% reservation?
At the time, that was their Lordship, the sons and the unmarried daughters of retired
That is
teachers.
fine, that is fine.
Lordship.
But for what purpose was this 10% reservation given?
For the post of assistant teacher, Lordship. For
No,
teaching
that's for, but for what purpose?
Lordship, it was a government scheme, Lordship.
Anyway, continue.
Lordship. Thereafter, Lordship, there was a letter by the headmaster of the school, page 22.
Yes.
Page 22 that was given by the headmaster to the inspector of schools regarding appointment of the petitioner. Prayer for appointment in the resultant vacancy with reference to a subject cited above, I beg to state that my elder son, Merunjyoti Borua, has been serving in Borajol High School since 1/11/1998 as an honorary assistant teacher as per the permission of ex-PWD and Forest Minister so-and-so. Again, he appeared in the interview of the district level selection board Nalbari and he was selected by the board in 1998. So I kindly request you that you have the kind approach to consider the case and appoint him in my resultant vacancy as may have retired on 30th April 2001. Lordship, his father was serving as the headmaster. Therefore, as the vacancy would occur, so it was a letter written to the inspector schools to appoint him, the petitioner, Lordship. Thereafter, Lordship, when nothing has been done, the petitioner approached his honorable court and there was an order of this honorable court at page 26, Lordship. It starts at page 26. Then page 27 is the operative part, Lordship. An observation was made, Lordship. The second para of page 27. Since there is a reservation in favor of the candidates in the category of the writ petitioner, any representation application filed by them has to be disposed of before the posts are filled by outside candidates. Thereafter, page 28, Lordship. In view of what is stated above, I dispose of this petition with a direction to the respondents to consider and dispose of the application's representations submitted by the writ petitioner in accordance with the provisions of law, along with other similarly situated candidates of the same category within a period of 3 months from the date when a copy of this order along with other documents are furnished to them. This was a direction given by this honorable court. Thereafter, Lordship, in compliance of this order, an order was passed by the inspector of schools, page 29, Lordship. The services of the petitioner was adjusted. He was adjusted and allowed to draw the monthly salaries against the transfer vacancies due to the transfer of Sri Manik Sarkar, Hindi teacher of Korbeli Bari High School, who transferred on so-and-so. This was done in compliance of the order passed by this honorable court. Thereafter, Lordship, another order was passed, page 31, that was also passed by the inspector of schools, whereby the services of the petitioner was adjusted and regularized in a retired vacant post, Lordship. That is at page 31, Lordship. Thereafter, Lordship, the petitioner was not paid any salary during that period of time. Therefore, he once again approached this honorable court and the honorable court issued a certain direction to the respondent authorities. Page 32 is the order, Lordship, of this honorable court. The type copy. There was a committee constituted in case of the similarly situated case like the petitioner's, Lordship. There was a constituted committee, and the honorable court, considering the matter in its entirety and in the interest of justice, this writ petition is disposed of with a direction to the respondents concerned to submit the case of the petitioner to the said committee for its examination and appropriate decision action. The whole exercise so directed shall be completed within a period of 6 months from today. That was a direction to place the case of the petitioner before the committee, lordship. There was a committee constituted as he was not given his salary, lordship. Thereafter, lordship, the order of this honorable court was of 2007, lordship. And after 7 years, in the year 2014, 22nd July, the impugn order was passed, lordship, page 34.
What does it say?
Lordship, I'll read the last part, lordship, the which I have challenged in this case, lordship. As reported by the DAC Assam, the order dated 3/8/2005 is prima facie illegal because the inspector of schools Nalbari is not competent authority to withdraw one post from the school and place at other school. This was blatant violation of existing government rules and procedures committed by the then inspector of schools Nalbari, district Nalbari by Sri so-and-so. As reported by the DAC Assam, a teacher appointed by managing committee is not eligible to get pay and hence the claim of the petitioner is not tenable. Order, the expert committee has observed that since the petitioner was an honorary teacher appointed by the managing committee, whereas managing committee is not empowered to issue appointment against government post, and secondly, his service was illegally adjusted by the then inspector of schools NDC Nalbari, therefore the committee has recommended rejection of the claim of the petitioner. Moreover, the committee also directed to the DAC Assam to take action against the erring officials who have irregularly appointed and regularized incumbent and issue the order to discontinue the service of the petitioner as per law. Lordship, thereafter, no order has been issued, and Lordship, the fact that he was the notification regarding the claim of the petitioner for the 10% reservation quota to the sons of the retired headmaster, that was also not reflected in the impugn order, Lordship. And Lordship, he is working till date, Lordship. He is working without receiving any salary, and no order has been issued, Lordship, regarding discontinuation of service. That is my case.
How were you appointed?
Lordship,
How were you appointed?
Lordship, I was appointed by the managing committee on Lordship, as an honorary
The provincialized school.
Lordship.
Yes,
Provincialized school, Lordship.
Then how can the managing authority appoint?
But Lordship, I had appeared in a board that is reflected in the letter, Lordship. There is a board selection. Lordship takes up the
Who
letter,
appoints
page
teachers
22.
in the provincialized schools?
It is, my lord, appointed by direct appointment. The school selection committee is there, and it is forwarded to the school inspector, and then it is director, and director is the appointing authority.
But Lordship, he appeared in an interview that has been reflected in the letter issued by the headmaster, Lordship, by the then headmaster, that he appeared in the interview of the district level selection board Nalbari, and he was duly selected by the said board in 1998. Thereafter, he was working, and at the same time, Lordship,
What board was it? What board was the headmaster?
that is
talking
a
about?
district level selection board, Lordship. And page 17, it is the Salan, Lordship. He have also appeared in a duly selection process because the Salan I have annexed, Lordship, page 17, for the post of assistant teacher in high school, Lordship. At page 17, Lordship, that is the Salan, Lordship.
Only 1998. 82, no? 82.
You appeared in the board in which year?
98, Lordship.
98.
Lordship.
This challan is dated
Salan, Lordship.
2009.
97, Lordship. 2197.
Who is it? Headmaster's letter.
Page 22, Lordship. 22 is the type copy, Lordship.
No, what happens after district selection committee, the district level selection board makes its selection?
Lordship, thereafter he was allowed to work, Lordship.
No, after
As-
that, the recommendation of the selection board will have to go somewhere.
Lordship,
to the higher authorities.
Lordship,
Was it done?
Lordship, that I am. I
Was
don't
it
know,
done?
Lordship.
My lord, appointing authority means the governor of Assam in respect of post of grade 1 cadre and the director of secondary education Assam in respect of the post in grade 2 and grade 3 cadres and inspector of school in respect of grade 4 and grade 7 cadres. So my lord, here inspector has appointed him illegally. So inspector has no role to appoint him.
No, where has the inspector appointed the petitioner?
In our affidavit, it is mentioned here.
Lordship, that one was done pursuant to the direction passed by this honorable court, page 29.
The inspector did not make any appointment. He adjusted the petitioner to a vacant
Adjust-
post.
Adjusted and regularized and
To a
allowed him to
first
go
to a
there.
transferred post.
Yes, my lord. But
What I'm asking is page 22. District level selection board
yes,
made its selection in 1998.
interview disciplinary level.
After that, what happened? Obviously, the selection committee recommendation will have to go to the higher ups. Page 22,
Yes, ma'am.
the middle para.
Again, he appeared in the interview of the district level selection board, Nalbari, and he was selected by the board in 1998. But my lord, here it is mentioned he was an honorary appointee.
He was an honorary appointee, which
Yes.
was not warranted, correct?
Yes,
Because the managing committee had no authority to appoint the petitioner
yes,
in a provincialized school.
yes, ma'am.
Okay, that one it goes. Number two is, here it says he appeared in an interview and the district level selection board recommended his case.
Yes.
What
My
happened?
lord, so far in this petition, he has come for the arrear salary, my lord. And regarding the arrear
So
salary,
for that area salary, we have to see what type of an appointment he had. Correct?
yes. And my lord, regarding the arrear salary in our High Court also rendered decision in Horendra Chandra Nath and others versus state. Here 2013 to GLT 1094. Here limitation is 3 years. Within that 3 years, he has to apply. He has to approach the honorable court for the arrear salary. But he has already after 7 years he came to the court. Here. This is the my lord. I'm allowed.
Lordship, he had approached the honorable court in the year 2007 and the honorable court had directed to place the case before the committee. That was of 2007 order, and the impugn order that we have challenged, that one is of 2014, Lordship. After 7 years, the committee has given a decision, Lordship. If Lordship comes to page
Yes.
30.
So he may have filed contempt petition. So as the direction of the honorable court is there that within 6 months, is a time limit is there, but within 6 months.
That
he
they
has,
did not do. He
done
just
anything.
waited for the committee to give his, for the director to give his decision.
Lordship. And he has been working, Lordship, in the
But at
school.
that 6 months, he has not done anything.
But that is,
No,
That is not the issue. Now the issue is this, whether he was he was legally appointed.
In our affidavit, it is.
I've read your affidavit. You said that the managing committee appointed you and the
And
school was a provincialized school,
yes,
and therefore the managing authority had no authority to appoint the petitioner, correct?
and
That was
thereafter,
in paragraph.
paragraph 6, my lord.
Seven.
6, my lord. In compliance to honorable court's order, the case of the petitioner was placed before the expert committee. The office of the deponent also submitted a detailed report on 30/7/2013. The expert committee observed that petitioner was an honorary teacher appointed by the managing committee without authority of law. It was also observed that adjustment order dated 3/8/2005 was illegal because Inspector of Schools Nalbari was not competent authority to withdraw one post from the school and place at the other school, which was done in violation of government rules.
I'm not talking
Therefore-
about this. I'm talking about your paragraph 7.
Paragraph, yes, ma'am. The deponent begs to state that the petitioner was appointed by managing committee of the school without following due process. The petitioner had not participated any selection process. The petitioner school was a provincialized school with effect from 1/10/1998, and in such school, the managing committee had no authority to appoint any person on honorary basis. The vacant post in the school was required to be filled up by way of direct recruitment by inviting application from the intending candidates for advertising.
That's what. Here you said he did not go through any selection process.
Yes,
This principal's letter says he appeared in the interview in the district selection committee, district level selection board. Nalbari.
so my lord,
Have you
record,
checked up the
a
records?
record may be required here.
Have you checked up the records? Is it necessary for this court to ask, call for the records? You have to check up the records. This control, this contradiction is there. In your paragraph 7, you said there was, he did not appear in any selection process. Headmaster is saying he appeared in the interview and was selected. This is an old matter. You should have already studied this case.
Earlier, I was not appeared in this matter, and in this
Whatever it
government
is,
after-
whenever the brief was handed over to you, you should have studied this matter. These are the just two things that are required. Your affidavit in opposition, paragraph 7,
Yes.
and the headmaster's letter. If the petitioner had appeared in that selection process,
Yes.
as indicated by the, and he was duly appointed, then from that date onwards, he is entitled to salary.
Yes.
Correct?
Yes.
Not from the day he was appointed as an honorary teacher.
Yes.
But if there was no selection process at all, then maybe petitioner will not be entitled to any other.
So my lord, after puja vacation.
But MS.
8 Talukdar law.
On a consultation. On request made by Sharma, studying council, secretary,
Secondary education department.
list after puja vacation.
Much obliged, sir.
24.
May I please, your lordship. Lordship, this matter is for non-payment of DC as the lordship, death come retirement gratuity lordship. Lordship, my case is that lordship, my husband was initially appointed as a master of labor lordship on 8/3/1981 lordship, which is at page lordship 9, annexure A.
1 minute.
Annexure A lordship. My husband's name is shown at serial number 6. Page 9, serial number 6, Mukul Das lordship. He was appointed on 17/7/19.
Page,
Page 9 lordship, annexure A.
yes.
Thereafter lordship, he was promoted to the post of Worksas lordship, Worksas Chokidar, which is at page 10, annexure B. Annexure B, page 10. In the interest of public service, Mukul Das, MR, so and so, is hereby appointed temporarily as Worksas Chokidar, so lordship, with effect from lordship, 16 July 1991. Then Lordship, his service was regularized, which is at page 12, Annexus C. Annexus C, Lordship. Page 12, regularization order. List is, Lordship, his name was shown at page number 14, Lordship. Page number 14, serial number 75, Mukul Das, Lordship. His service was regularized with effect from 22/7/2005, Lordship. So, Lordship, my husband has three types of services, Lordship. One, master of labor. Master of labor with effect from Lordship from 8/3/1981 to Lordship 81 to Lordship 16 to 1991. Total Lordship 9 years, 11 months, 8 days. Thereafter, Lordship works as service. Works as service, so far my calculation is 14 years, 5 months, 4 days. And then Lordship regular service is 7 years, 11 months, 9 days, Lordship. Regular service with effect from 22/7/2005 to 1/7/2013. He died on 1/7/2013, Lordship. After his death, Lordship, I applied for pension, Lordship, and service benefits, Lordship, other service benefits, including the gratuity. And accordingly, my family pension was sanctioned, which is at page 16, Annexure D, Lordship. Annexure D. PPO is at page 17, Lordship, Annexure E. 11 part is at page 18. 18. My family pension was sanctioned, Lordship, considering the length of services, Lordship. Here, Lordship, may kindly come to the clause number 7. Clause number, Lordship, 6. Page, Lordship, 18. Part of PPO, Lordship. Clause 6. Class of pension, family pension, gross service, 21 years, 11 months, 16 days. Non-qualifying service, 3 years, 0 months, 0 days, Lordship. It came to 18 years, 11 months, 6 days, Lordship. And due to that, Lordship, I was not paid the death cum retirement gratuity. For entitlement of death cum retirement gratuity, Lordship, 20 years service is required, Lordship. Now the law is settled by this Honorable Court as well as by the Honorable Apex Court, Lordship. Lordship, whole period of services is required to be counted. So far, Sangeeta Rai passed by this Honorable Court. And I had one similar case, Lordship, for non-payment of DCRG, and this Honorable Court passed an order. Your Lordship, may kindly. In Sangeeta, main case is Sangeeta Rai, Lordship. Sangeeta Rai, here the Honorable Court held, Lordship, in paragraph number, Lordship, 28, 29, 29. 29 and 30, Lordship. Sangeeta Rai.
1 minute.
This is followed by Sangeeta Rai. Once may hold on.
On the PPO,
Lordship,
page 18.
my PPO.
Yes, page 18.
Page 18, Lordship. 18, Lordship.
What is this non-qualifying service? 3
Lordship,
years?
3 years, Lordship.
From where is it coming?
Lordship, from the workshop service, the 3 years was deducted. There was one office memorandum, Lordship, for deduction of 3 years.
Oh.
And Lordship, That part was decided by this court in Sangita Rai Lordship.
That
Whole period of services is required to be counted.
that memorandum was set aside.
Lordship, it was reported, Lordship, many cases were settled pursuant to the Sangita Rai Lordship. May kindly, Sangita Rai, this is the Sangita Rai Lordship. This is the. It is also reported, Lordship, in 2019 to GLT 805. 29 and 30 paragraph, Lordship. Twenty-nine and 30 paragraph number, Lordship.
Yes.
Lordship, it is only my case, and in this case, Lordship, the respondent authorities have filed their affidavit. Their only claim is that, Lordship, after deduction of initial 3 years, my service, his service turned into, Lordship, 18 years, which is less than 20 years. For which, Lordship, I was not paid the debt-cum retirement gratuity. That was the claim of the respondent authorities, Lordship. Both the state respondent as well as the accountant general filed their affidavit. Lordship, running page number 28, affidavit filed by the respondent number 1 and 2.
Yes.
Here, Lordship, their stand is at serial at point number 4, paragraph number 4, Lordship. Nothing is disputed. My services are not disputed, Lordship. And the stand is only that, Lordship, point number 4, that as regard a statement made in paragraph number 4 of the writ petition is concerned, it is stated that for eligibility of gratuity, late Mukul Das was required to serve for more than 20 years in the capacity of worksas and regular Sokidar. But his service period, which qualifies for pensionary benefits, is only 18 years, 11 months, 15 days. That is after deduction of 3 years, as per guidelines from his total service period, which is 21 years, 11 months, and 15 days. This is the stand of the state respondent. And Lordship, the accountant general will also file their affidavit. Running page is from 31. Part is paragraph number 5 of the affidavit filed by the accountant general.
Yes, we are pressed on the others.
The difficulty is that everything is dealt by the SCPWD, Lordship. I am here representing the respondent number 4 only, Lordship. Apparently, respondent number 4 has no role, Lordship. This is between the department and the
Who
accountant general,
appears for
Lordship.
the respondent?
Yes, Lordship. 1, 2, 3 at the department. Public
Who
Works
appears for
Department.
PWD? Public
Yes,
Works.
yes, Lordship, and they have filed the affidavit also.
Affidavit filed, Lordship, their only stand is that after
No, that's
deduction.
fine, but let us see, where the,
Yes, Lordship, I have put a message, Lordship, but no one is responding. For
Lordship,
the
who is the standing-
SCPWD.
who is the
Well,
standing
Lordship,
counsel?
There are so many lordship.
Not lordship.
Okay, but Mr.
East Taluda lordship.
is the local in the council petition. Also heard MSM Bhattacharya, the addition senior government for respondent for. Non-appeals for the respondents, 1, 2, and 3. And respondent. Accountant general, anybody separating? No one.
No lordship for accountant general also no one. This is between the department and the AG lordship. We are just made a party only.
After puja vacation.
Lordship, in the matter may be list on the top of the list, lordship. It is a long pending matter, lordship.
That will see, yeah.
A date may be fixed, lordship.
21st November.
Top of the list, lordship. Will
No, will come up.
of lordship.
Deeply obliged and not.
25.
May it please your lordship.
1 minute. Who appears for the union?
Yes, lordship, I am appearing for the respondents.
Accountant general, Nagaland. You are appearing for accountant general also?
Nagaland. Nagaland, lordship.
What 5 and 6? And union you are appearing for 1 to 4?
I am appearing for 2, 3, lordship. 2, 3, and 4.
Yeah.
1 is not there. 6.
Young is there's
My lord, although it's late in the day, this is a very, the petition is an old lady. And the claim in substance, without going to nitty-gritties, my lord, is whether or not the petitioner is entitled to pension. Number 1. The pension would fall under the state of Nagaland as also NIT Silchar. Initially, she was working in the state of Nagaland. Then, through proper channel, she came to REC Silchar. She was on leave, madam. Subsequently, there. And she retired from Nagaland after giving considerable years of service for pensionable service. Now, the pension from the state of Nagaland at a particular point of time was deducted from the salary of the petitioner by the REC Silchar. Subsequently, REC became NIT. Now, when the petitioner retired from the NIT Silchar, they are not paying pension to the petitioner. All throughout the lifetime, the pension from the Nagaland was being deducted illegally. Thereafter, now after she retired, she is not being paid the pension from REC. On the count that.
so Nagaland's only a pro forma.
My lordship.
Nagaland?
Not Nagaland, no. Nagaland would be a necessary party to the extent they are confirming the status, even not disputed by anyone. It's an admitted position. The act of the REC and then the NIT Silchar in illegally deducting pension so received by me from the state of Nagaland is a cause of action for me, number 1. Number 2, all throughout. I'll give the date when I retired from Nagaland, when the pension started, and they continued till 2004 December to deduct it. From 2004 December, when I retired in REC Silchar, I mean NIT now, then they refused to pay me pension. They take a plea, and if I may read out, that the CCS pension rules 7.2 is applicable.
Anyway, start with your facts.
My lord. If I may point out the relevant facts,
Lordship, before my learned friend starts, there's an order of this honorable court, the last order, 3rd of January 23. I don't know, I have not received any copy whether they're filing an affidavit with regard to that.
The answer is no.
There's a specific direction.
What affidavit?
No, we have not filed any affidavit to produce. She's a very old lady in the last stage of her life. Fragile health, breaking bones here and there.
The appointment letter.
I understand, Miller could not get hold of any document
There's
whatsoever.
already a judicial order.
I understand, Miller. We have stated that on the last occasion also, and they were to produce the records.
3123, this is the last order.
I had word with my client, Miller. She's not in a position to trace out or find. She does not retain any copy or so whatsoever. And I stated that earlier also. This is the stamp. Their refusal to grant me pension is under Rule 7.2, which is not even applicable to me.
Will you be having the appointment order?
They say it's a re-employment.
Re-employ, where's this?
They say it's a re-employment.
Whether it's re-employment or appointment order,
Absolutely, that's the case.
you'll have the copy, isn't it?
No, re-employment, in our affidavit also have taken a specifically with regard to that. It's a case
The
of
document is
re-employment.
missing.
And there is the reason why the 7.2 is applicable in this.
No, whatever it is, whether it's a re-employment or an appointment order, you'll have a copy.
No, this is if it is a re-employment, then there is no copy of the appointment.
That's it.
That is the thing.
That's the case, Miller. They take a plea, it's a re-employment without furnishing any document to show that it is a re-employment. I have taken a specific stand. My services in the state of
It
Nagaland,
is the case of the petitioner. If she has been appointed, then she can have a copy with regard
my
to
lordships,
her appointment.
this is
letter.
too far-fetched to say. I take my lord to Rule 7.2 to show exactly what the case is all about.
No, let us come to the point.
My lord.
He's saying your case is a case of re-employment.
My lord.
You are saying yours is a case of
Fresh appointment.
fresh appointment.
Fresh appointment. After the Nagaland chapter is over, initially I was on leave. Subsequently, that part is gone. I was given pension there, pension there, and I got employment here. I was young in age, so I got employment here. I retired in 2004 at the age of 62. And in Nagaland, Miller, it was 31/3/1988. From 88, I retired there to 62. I was in their service. 2004, their service. The point which props up, two different services, one under state government, one under the REC, and then the NIT. Two different services, two different capacity. But the 7.2 is even remotely applicable. Assuming for the time being, the points ought to be mooted. The authorities are falling short of any document to show it's a re-employment. They are not denying the fact I was employed there. My employment is not in a dispute. It is a stand taken, a plea without any document. Now it has fallen from him, Miller. There is no document. We have umpteen times stated in affidavit that my appointment or employment under the NIT is not in dispute.
Mr. Chowdhury, there's no appointment order or a re-employment order?
Lordship, in
On what basis have you appointed? the
exactly,
petitioner?
Lordship, in our affidavit, if I go to the affidavit, there is a specific statement in our affidavit. In paragraph number 10. Before that, paragraph number 5. The petitioner was appointed as lecturer in the Department of Humanities and Social Science in Restwell REC Silchar and joined the same institute on 6/4/84, and while joining the Restwell REC, she applied to her parent department for maintaining lien on the post of teacher, selection grade in scale of such and such, still her confirmation in the REC Silchar. It's a case of confirmation. Paragraph number 5. Paragraph 5, Lordship. It's a page number 2. Petitioner was appointed as lecturer in Department of Humanities and Social Science in Restwell REC Silchar.
See, on joining REC Silchar,
And joining the same institute.
her pay was fixed at the rate of rupees.
Yes, he
600.
applied
Where's
to parent
this-
department for maintaining lien on the post. That was a lien.
Where's this order fixing her salary? At
Selection.
least let us see that.
They were also asked to produce the records for that.
Record I'm having. The entire
Do you have a copy of this?
Yes, yes,
order?
the entire record I'm having, Your Worship.
We're fixing our salary at
Yes,
rupees
yes,
940.
I'm just giving all the details. In our additional affidavit also, Lordship, if your Lordship kindly see the additional affidavit, annex one document, page number 5. Also got it, this additional affidavit at page number
Yes,
5.
yes.
This is from the Respondent, the REC Silchar. I am to refer to the above and to say that we have been granted pension at the rate of such and the pension equivalent to gratuity with respect to such and such for undergoing voluntary retirement from your present department while joining in the service of the institute on such and such. You had retained lien against the service with the government of Nagaland as confirmed as confirmed graduate teachers, but you did not inform the fact of the termination of lien by your undergoing voluntary retirement from the service of the present parent department, that is government of Nagaland. Also, you did not inform the fact of your pension granted to you by your parent department till your letter number such and such, dated such and such, addressed to the Secretary of the Government of Nagaland Education Department. Copy endorsed to this institute has been received, written in pursuance of the letter under reference from accounts officer such and such. Also, fortunately, come to your notice on your receiving of the aforesaid pension equivalent to gratuity, your pay is rendered to be readjusted in accordance with the government rule. You are therefore requested to clarify the position of the earliest. So that was communication was given to the petitioner in the year 1989 with regard to the fact that she was on lien and accordingly she took her voluntary retirement from the government of Nagaland, and that was not never been communicated to the NIT Silchar or the REC Silchar.
They are trying to cover up the point of the re-employment. They have the records to show.
Yes, sir.
It's a re-employment.
I'm just showing all the papers.
Just seen the reports.
And after that, I'll refer to the rules and effects.
You've not gone through the record.
Yes, yes. I flag marked the record. I'm just giving the.
You should have flagged the records by
Yes,
now.
yes, these things are there.
Their ground of 7.2 is very categorical, which is 3-4 lines. If I may read that, Miller. What the 7.2 all about? Except as provided in Rule 19, that is military service, Miller. That's not. A government servant who, having retired on superannuation pension or retiring pension, none, my case is none, is subsequently re-employed, shall not be entitled to separate pension or gratuity for the period of his re-employment. The preconditions are missing. Retiring pension, superannuation pension, I did not retire under those heads. And there is no question of re-employment.
No, this is not the one. I'm talking about fixing our salary at rupees 940.
That record.
You better,
First, I'm just giving the record. It is there.
you should have flagged it by now. This court can't keep on waiting.
It is there. But not. That's it.
अभी की बात बाहर बाहर मोबाइल पर
Yes. People.
Yes, thank God. But there's money clearer counsel for the petition. Oh, that is- Who is appearing? Kichi? Additional Advocate General for the respondents. Respondent number? 6. Stop. On request made by SP Chaudhary. Leonard
2, 3, 4 Lordship.
Learned counsel for respondent number 2, 3, and 4. Please, after the puja.
my lord, she's a very old lady. Can I pay for tomorrow, my lord? She's a very, very old lady, my lord. I feel sorry for her time. Otherwise, I would not make.
Tomorrow.
Let Thursday, my lord.
Thursday.
Thursday.
No.
Thursday.
You can take back this.
That particular annexure, yes. I'll
You
get
can take back this
that. Yes,
document.
yes,
also.
yes.
I'm so grateful.